The House will come to order. Today, the Pledge of Allegiance will be led by Casey Dana, Jackson Dana from Murphy Creek School, Aurora, Colorado, guests of Representative Michael Carter, House District 36.
Will you please join us for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Armagost, Bacon, AML Bacon. Bacon's excused. Barone, Byrd, Basenecker, Bottoms, Bradfield, Bradley, Brooks, Representative Brooks. Brooks is excused. Brown, Caldwell, Camacho, Carter, Clifford, DeGraff, Duran.
She's here.
English is excused. Espinoza, Ferre, Representative Ferre, Froelich, Garcia, Garcia Sander, Gilchrist, Gonzalez, Representative Gonzalez, Hamrick, Hartsook, Jackson, Johnson, Joseph, Kelty, Leader, Lindsay, Linstead, Luck, Lukens, Mabry, Marshall, Martinez, Morrow, McCormick, Pascal, Phillips, Puglisi, Richardson, Ricks, Representative Ricks. Ricks is excused. Rutinel, Ryden, Sirota, Representative Sirota. Sirota's excused. Smith, Soper, Stewart K, Stewart R, Story, Sukla, Taggart, Titone, Valdez A, Velasco, Representative Velasco. Velasco is excused. Weinberg, Wilford, Winter, Woodrow, Woog, Zokai, and Madam Speaker.
With 60 present, 5 excused, we do have a quorum. Representative Camacho.
Good morning, Madam Speaker. It's an honor to serve with you.
It is an honor to serve with you.
And good morning, colleagues. How's everyone doing today?
Great.
All right. In continuation of my 3-day tradition of spotlighting different constituents and communities in my district, next up is the great C.L. Harmer from Windsor Gardens. I know she's watching on the Colorado Channel. CL Harmer, as many of you may not know, has served many years of distinction as staff in this chamber many years ago. And CL says for her joke today, what do doctors get when they are frustrated? They lose their patience. Woo! They're getting better. Madam Speaker, I move the Journal of Wednesday, February 5th, 2025 be approved as corrected by the Chief Clerk. And for those of you counting, only one more day.
Woo! Members, you've heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Members, I'll invite you to take your seats. We are moving on to third reading. Members, we are moving on to thirds. Please take your seats. Mr. Schiebel, please read the title to House Bill 1084.
House Bill 1084 by Representative McCormick, also Senators Marchman and Simpson, concerning the substitution of gender-neutral language for gendered language in Title 35 of the Colorado Revised Statutes.
Madam Majority Leader.
Thank you, Madam Speaker. I move House Bill 1084 on third reading and final passage.
The motion before us is the adoption of House Bill 1084. Representative Bradley.
Thank you, Madam Speaker. I'd like the bill to be read at length.
The request is for the bill to be read at length. That is allowed on third readings. Please proceed.
House Committees, Senate Committees, Agriculture, Water and Natural Resources. A bill for an act. 101 concerning the substitution of gender-neutral language for 102 gendered language in Title 35 of the Colorado Revised 103 statutes. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Water Resources and Agriculture Review Committee. The bill substitutes gender-neutral language for gendered language in Title 35 of the Colorado Revised Statutes. The bill also updates archaic language in Title 35. House second reading unamended February 5, 2025. House sponsorship McCormick, Martinez. Senate sponsorship Marchman and Simpson, Bridges, Roberts. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. 1. Be it enacted by the General Assembly of the State of Colorado, 2 Section 1. In Colorado Revised Statutes, 35-1-102, amend the 3 introductory portion and 1, as follows, for 35-1-102. Definitions. As used in this article, Article 1, unless 5 the context otherwise requires. 6. 1. Agriculture means the science and art of production of 7 plants and animals useful to man humans, including, to a variable extent, 8 the preparation of these products for man's human use and their disposal 9 by marketing or otherwise, and includes horticulture, floriculture, 10 viticulture, forestry, dairy, livestock, poultry, bee, and any and all forms 11 of farm products and farm production. 12 Section 2. In Colorado Revised Statutes, 35-1-106, amend 13-1-E, as follows, 1435-1-106. Powers and duties of Commission, rules. 1. In 15 addition to all other powers and duties conferred upon the Commission by 16 this Article 1, the Commission has the following specific powers and 17 duties. 18-E. To furnish the Commissioner with advice on any agricultural, 19 or livestock problem with which he the Commissioner may be 20 confronted, 21 Section 3. In Colorado Revised Statutes, amend 35-1-109 as 22 follows, 2335-1-109. Employees interchangeable. It is the duty of the 24 Commissioner of Agriculture in the administration of his department to so 25 shall organize the same department so that all employees of the 26th department, so far as possible, shall be are interchangeable in work. Dash 2, 1084. 1 assignment to the end so that they may be shifted within the department. 2 so as to meet seasonal and emergency demands upon any division or 3 section of the department and so that the number of such help for employees is kept to a minimum possible for efficient operation. 5 Section 4. In Colorado Revised Statutes, amend 35-2-101 as 6 follows, 735-2-101. Information furnished, by whom? The Commissioner 8 of Agriculture, acting under the direction of the State Agricultural Anine Commission in the collection of information necessary to the performance 10 of his or her perform the Commissioner's duties as such. Commissioner 11 and subject to the provisions of Section 24-1-136, CRS, in regard to the 12 publication of such information, is authorized to may call upon the 13 several state, county, city, town, and school district officers and officers 14 of the several state institutions of education and penal and other state 15 institutions, and it is the duty of all such officers to furnish, upon written 16 or printed request of the Commissioner, such information as may be 17 required for properly setting forth the resources of the state and their 18 development, upon blanks furnished by the Commissioner. Upon request 19 of the Commissioner, each owner, operator, or manager of any 20 manufacturing, mining, or other business establishment operating in this 21 state, or other person having information necessary for carrying out the 22 purposes of this article, upon the request of the Commissioner. Article 2, 23 shall furnish the same information upon blanks supplied by the 24 Commission. Except as otherwise provided by law, any agricultural 25 statistics collected by any of the several state, county, city, town, school 26 district, or institutional officers specified in this section shall be collected 27 in accordance with the requirements of this article. Article 2. 3, 1084. 1 Section 5. In Colorado Revised Statutes, amend 35-2-102 as 2 follows, 335-2-102. Statistical reports. It is the duty of the assessor of each 4 county in this state, at the time of making the annual assessment of 5 property, to collect such statistics in relation to the population, farm 6 operations, the principal farm products, agricultural resources, and 7 livestock of the county as may be required by the Commissioner of 8 Agriculture. And it is the duty of all persons within this state having 9 information relative to such matters to give such information to the 10 assessor upon the assessor's request. Therefore, the original sheets 11 on which such statistics are collected shall be forwarded to the 12 Commissioner of Agriculture as soon as they are completed, but not later 13 than June 1st of each year, immediately following their collection. From 14 these the State Agricultural Commission shall compile the 15 original sheets there shall be compiled in the office of the State 16 Agricultural Commission into complete reports on all subjects covered for 17 each county in the state. The blanks to be used by county assessors in the 18 collection of statistics required by the State Agricultural Commission shall 19 be supplied by the Commission, and the form thereof shall be fixed by the 20 Commissioner of Agriculture after conference consulting with the 21 representative of Colorado State University and with the Bureau of Crop 22 Estimates of the United States Department of Agriculture, or any 23 successor organization, through the official representative for 24. Colorado. This report shall be issued subject to the provisions of Section 2524-1-136. CRS. 26 Section 6. In Colorado Revised Statutes, amend 35-2-103 as 27 follows. 4, 1084. 135-2-103. Cooperation with Secretary of Agriculture. To facilitate the work of collecting agricultural and livestock statistics 3 required by this article. Article 2, the Commissioner of Agriculture is empowered to may enter into a cooperative agreement with the Secretary 5 of Agriculture of the United States, or his the Secretary's accredited 6 representatives, under which the facilities and information of the Bureau 7 of Crop Estimates of the United States Department of Agriculture, or any 8 successor organization, relating to the State of Colorado are made 9 available for the use of the State Agricultural Commission, and the 10 facilities and information of said the State Agricultural Commission are 11 likewise made available for the use of said the Bureau of Crop Estimates, 12 or any successor organization. 13 Section 7. In Colorado Revised Statutes, amend 35-2-104 as 14 follows, 1535-2-104. Failure to give information to Commission, penalty. 16 Any person having in his the person's possession information necessary. 17 to carrying out the purposes of this article. Article 2 who fails or refuses 18 to furnish such the information to the State Agricultural Commission upon 19 proper request by the Commissioner of Agriculture is guilty of a 20 misdemeanor and, upon conviction thereof, shall be punished by a fine of 21 not less than $10 nor more than $500 and costs of 22 prosecution. Any county or state official who fails or refuses to collect or 23 compile for the State Agricultural Commission such the information as he 24 the official is required by this article. Article 2 to collect and compile, 25 when properly requested by the Commissioner of Agriculture so to do, and 26 who is supplied with proper blanks for collecting and compiling the same. 27 is guilty of a misdemeanor and, upon conviction thereof, shall be 5, 1084. 1 punished by a fine of not less than $20 nor more than $200 and costs of prosecution. 3 Section 8. In Colorado Revised Statutes, amend 35-3-109 as follows. 535-3-109. Community and County Committees, Rules. 1. The 6th Department by Regulations rule shall provide, 7a, for the organization within each community of a voluntary aid association, in which all agricultural producers who are citizens of this 9th state and residents in such community are entitled to equal 10 participation, for the selection by each such association of a Community 11 committee, composed of 3 members of such association, and for the 12 selection of a chair of each such committee, and 13. B. For the selection by the members of such community 14 committees within each county of a county committee for such county, 15 composed of 3 members of such community committees, and for the 16 selection of a chair of each such county committee. 17 Section 9. In Colorado Revised Statutes, 35-3.5-102, amend 18, 7, as follows, 1935-3.5-102. Agricultural operation deemed not nuisance, State 20 Agricultural Commission, attorney fees, exceptions. 7. A local 21 government may adopt an ordinance or pass a resolution that provides 22 additional protection for agricultural operations, except that no such in 23 ordinance or resolution shall not prevent an owner from selling his or her 24 the owner's land or prevent or hinder the owner in seeking approval to 25 put the land into alternative use. 26 Section 10. In Colorado Revised Statutes, 35-4-107, amend 27, 3, as follows. -6, 1084. 135-4-107. Inspections, notice, treatment, collection of costs. 2, 3, upon payment by the Board of County Commissioners of any cost and 3 expense of treating pest infestation or infection in accordance with 4 subsection 2 of this section, the county shall demand in writing from the 5 owner, in person or by mail addressed to the owner at his or her the 6 owner's last known place of residence, reimbursement to the county for 7 the amount of the county's direct costs and expenses only. The county 8 shall not send a written demand for more than $10,000. In the 9 written notice, the county shall inform the owner of the right to appear 10 before the Board of County Commissioners at any meeting thereof of the 11 Board, as fixed by law, to be held within the following 4 months, and 12 be heard as to the amount of the claim for reimbursement. If the claim, as 13 originally demanded by the Board or as adjusted upon a hearing, is not 14 paid at the end of the 4-month period, the Board shall certify the claim. 15 to the County Treasurer of the county where the property is located. The 16 County Treasurer shall add the amount of the claim to any taxes due, or to 17 become due, from the owner, and if the claim is not paid in due course, 18 the County Treasurer shall file a lien on the property. The lien's priority is 19 based upon the date of recording in accordance with Article 35 of Title 38. 20 CRS. The Board of County Commissioners shall work with any 21 landowner to develop a payment schedule for the cost of an assessment 22 for pest treatment upon a demonstration by the landowner of an economic 23 hardship. All accounts when collected must be deposited into the General 24 Fund of the county. 25 Section 11. In Colorado Revised Statutes, amend 35-4-109 as 26 follows, 2735-4-109. Emergency Disposal of Plant Material. NEA. -7, 1084. One shipment of any plant material into Colorado when that IS found to be 2 in violation of a quarantine declared pursuant to Section 35-4-110 or when 3 found to carry exotic pests not previously found in the United States or 4 pests known to cause high levels of economic damage under similar 5 conditions of climate and natural habitat in other areas outside this state. 6. By the Commissioner may be placed in isolation or quarantine by the 7 Commissioner and shall be completely under the Commissioner's control. 8. The owner or bailee shall comply with all terms of the quarantine, abate 9 such pests as directed by and to the satisfaction of the Commissioner, or 10 remove such shipment from the state within such time as ordered by the 11 Commissioner. Articles not removed from the state as ordered shall be 12 destroyed by the Commissioner with no recompense therefor to the owner. 13. Any owner or bailee claiming that his or her the owner's or bailee's 14 shipment of plant material was destroyed or ordered removed from the 15 state without reasonable justification may request a hearing on that issue 16 before the Commissioner within 10 days after such destruction or order 17 of removal. If it is determined that a shipment of plant material was 18 destroyed or ordered removed from the state by the Commissioner without 19 reasonable justification and that such action was done arbitrarily and 20 capriciously, the Department of Agriculture shall reimburse such owner or 21 bailee for any losses suffered. 22 Section 12. In Colorado Revised Statutes, amend 35-4-113.523 as follows, 2435-4-113.5. Delegation of duties. The Commissioner, in his at 25 the Commissioner's discretion, may delegate his the Commissioner's 26 authority to an employee to execute the provisions of this article. Article 27-4. -8, 1084. 1 Section 13. In Colorado Revised Statutes, amend 35-4-116 as 2 follows, 335-4-116. Rules. The Commissioner may promulgate adopt such 4 rules and regulations as he the Commissioner deems necessary for the 5 administration and enforcement of this article. Such Article 4. The Rules 6 and regulations shall be promulgated adopted in accordance with Article 7-4 of Title 24. CRS. 8 Section 14. In Colorado Revised Statutes, 35-5-101, amend 9 the introductory portion, 12, and 12.1, as follows, 1035-5-101. Definitions. As used in this article, Article 5, unless 11 the context otherwise requires. 12. Resident landowner means a person who owns 5 or more 13 acres of land within the boundaries of the proposed district and has his 14 whose legal residence is within the county where the proposed district is 15 located or within an adjacent county. 16. 12.1. Resident lessee means a person leasing 5 or more acres. 17. Of state-owned land controlled by the State Board of Land Commissioners. 18. Within the boundaries of the proposed district and having his whose legal 19 residence is within the county where the proposed district is located or 20 within an adjacent county. 21. Section 15. In Colorado Revised Statutes 35-5-104, amend 22, 1, 5, and 8 as follows. 23 35-5-104. Pest Control District, procedure to establish. 24, 1. Whenever 25% of the resident landowners and 25 resident lessees within a contiguous territory desire to form a pest control 26 district, as defined described in this subsection, 1. They may file a 27 petition for that purpose with the Board of County Commissioners of the -9, 1084. One county in which the land is located. Such petition shall be addressed to the Board of County Commissioners of such county, and shall must 3. Contain a description of the boundaries of the proposed district and a 4. Description of the land of each person signing such petition, and shall 5. Must state that the said proposed district has been invaded, or is in danger 6. Of being invaded, by noxious weeds, insect pests, or plant diseases 7. Injurious to agricultural crops, trees, fruits, or pasture, and shall must 8. Name the specific pests or diseases against which said the petitioners 9. Desire to be protected, and shall must state the termination date of the 10 proposed district. Such the petition shall be signed by each resident 11 landowner and resident lessee joining in the petition by his the 12 individuals proper signature together with his and address, and the date 13 of the petition shall must be the date of its filing in the office of the board. 14. Of County Commissioners. Any a petitioner may revoke and cancel his. 15. The petitioner's signature to such a petition at any time before said the 16 petition is filed, but not after such filing has been made. 17. 5. If the owner or lessee of any lands adjoining an established 18 pest control district desires to have such lands included within the district. 19. He the owner or lessee may petition the Board of County Commissioners 20 of the county in which the district is located and to which District 21 annexation of his the land is desired. The petition shall must contain a 22 description of the boundaries of the land so desired to be annexed and 23 shall be signed by the petitioner. The board shall act on said the petition 24 within 10 days after the receipt thereof receiving it. If the board finds 25 that the petition is in order, that the boundaries of the lands described in 26 the petition are accurate, that the lands adjoin the established district, and 27 that the petition is properly signed, it the board shall, by order, declare. 10-1084. 1. That the lands petitioned to be annexed to the district shall be included as to a part of the district. Within 10 days after such taking action upon the 3 petition, the board shall notify the petitioner, the county assessor, the 4 district advisory committee of the district in which such the lands are to 5 be included, and the Department of Agriculture of its the board's action. 6. 2 or more owners and lessees of lands adjoining an established Pest 7 control district may join in and sign a single petition for annexation of 8 their adjoining lands to an established district in the manner prescribed in 9 this subsection. 5. 10.8. When a pest control district which that was established for 11 the control and eradication of specified pests desires to add additional 12 pests to be controlled within the district, the District Advisory Committee 13 shall petition the Board of County Commissioners of the county in which 14 such the district is located, requesting that a stipulated pest or pests 15 should be added to the pests to be controlled in the district. The Board of 16 County Commissioners shall act on the petition within 10 days after 17 receipt thereof receiving it. If the Board of County Commissioners 18 determines that such pests should be controlled within the district, said 19 the Board shall submit the question to all landowners and lessees of the 20 district by causing to be mailed to each landowner and lessee, to the 21 address as shown by the records of the County Assessor or State Board of 22 Land Commissioners, a ballot requesting his the landowners or 23 lessees vote for or against the addition of the stipulated pests to be 24. Controlled within the district and the return of such the ballot within 10-25 days to the Board. If 51% of the landowners and lessees 26 voting in the district vote in favor of the inclusion of said the stipulated 27 pests within those to be controlled, the board shall immediately declare. 11-1084. 1. That the stipulated pests shall be controlled within the district and shall so too inform the District Advisory Committee. 3. Section 16. In Colorado Revised Statutes, amend 35-5-106 as follows. 535-5-106. County Pest Inspector, Deputies, and Employees. The 6th Board of County Commissioners of the A county concerned may appoint 7 a qualified person, subject to the approval of the Commissioner and 8 District Advisory Committee, as County Pest Inspector. It is the duty of said 9 the Inspector to shall carry out the Inspector's duties as provided 10 in this Article 5 under the direction of the Board and the 11 Commissioner. The Inspector, with the approval of the Board, may employ 12 such deputies and employees as are necessary to perform the 13 Inspector's duties under this Article 5. The Salary Board shall 14 determine the salaries of the Inspector and of the Inspector's 15 deputies and employees. Shall be determined by the Board. 16. Section 17. In Colorado Revised Statutes, 35-5-108, amend. 17, 4, and 6, b, as follows. 1835-5-108. Control or eradication methods and procedures. 19. Notice, assessments, protests. 4. If any a landowner within the 20 district is dissatisfied with the itemized statement of expense he 21 described in subsection 3 of this section, the landowner may, 22 within 30 days from after the mailing or publication of the account 23 showing such the charge, file a written protest with the Board of County 24 Commissioners. Not later than 10 days after the filing of such the protest. 25 The Board of County Commissioners shall fix a time and place for hearing. 26 On the protest filed, to be held not less than 10 days nor more than 27 days from after the date of notice of the hearing, and, immediately after. 12, 1084. 1 Such the hearing, the Board of County Commissioners shall make written 2 findings and such changes in the assessment as may be determined to 3 conform with such the findings. 4. 6. B. If any lessee within the district is dissatisfied with the 5 itemized statement of expense he described in subsection 3 of this 6th section, the lessee may file a written protest with the Board of County 7 Commissioners as provided by subsection 4 of this section. 8. Section 18. In Colorado Revised Statutes, amend 35-5-110 as 9 follows. 1035-5-110. Public nuisance abatement. Any noxious weeds, 11 insect pests, or plant diseases with respect to which a control district has 12 been proclaimed in any and all stages thereof, their carriers, and any and 13 all premises, plants, and things infested or exposed to infestation 14 therewith with noxious weeds, insect pests, or plant diseases within 15 such area are declared to be a public nuisance, subject to all laws and 16 remedies relating to the prevention and abatement of nuisances. The 17 Inspector, under the supervision and direction of the Commissioner, and 18 with the approval of the Board of County Commissioners, in a summary 19 manner or otherwise, may take such action, including removal, and 20 destruction, with reference to such a nuisance as in his the Inspector, 21 in the Inspector's discretion, deems necessary. The remedies of 22 this section shall be are cumulative with all other remedies provided in 23 this article Article 5. 24 Section 19. In Colorado Revised Statutes, 35-5-111, amend 25, 1, as follows, 26 35-5-111. Reports of acreage infested, county tax levy, Fund 27, allocation. 1. The Commissioner is directed, and it is his duty, to 13, 1084. 1 shall ascertain each year, from reports of the inspectors and other 2 sources, the approximate amount of land and highways infested with the 3 most troublesome noxious weeds, insect pests, or plant diseases, and their location, and transmit such information tabulated by counties, not later 5 than July 1st of each year, to the Board of County Commissioners of each 6 county affected by such infestation. On the basis of such information, the 7 Board of County Commissioners of each county may make a tax levy each 8 year on real property for the purpose of paying the cost of noxious weed, 9 insect pest, or plant disease control or eradication in a district of the 10 county as provided by this section, but such levy shall must not exceed 11.2 mils in any 1 year. 12 Section 20. In Colorado Revised Statutes, amend 35-5-113 as 13 follows, 1435-5-113. Deputy or agent may exercise power. Whenever any 15 power or authority is given by any provisions of this article 16.5 to any person, if the power or authority may be exercised by any 17 deputy or agent duly authorized by him the person. 18 Section 21. In Colorado Revised Statutes, 35-5-117, amend 19, 1, as follows, 2035-5-117. Emergency measures, Governor. 1. When the 21 Governor determines and declares an emergency resulting from a major 22 grasshopper or range caterpillar infestation, he the Governor shall 23 specify the area or areas of the major infestation. Within such area or 24 areas, he is authorized to the Governor may direct that such emergency 25 measures be taken as he the Governor deems necessary to alleviate 26 conditions which that gravely jeopardize property and resources. 27 Section 22. In Colorado Revised Statutes, 35-5-120, amend. 14, 1084. 1, 4, as follows, 235-5-120. Grasshopper and range caterpillar control. 4. If the 3 Commissioner, with approval of the District Advisory Committee, as forestablished in Section 35-5-105, determines at any time that Control 5 operations would not significantly reduce the grasshopper or range 6 caterpillar populations in the established control districts, he the 7 Commissioner may order that said the operations be suspended or 8 terminated. 9 Section 23. In Colorado Revised Statutes, 35-5.5-103, amend 10 the introductory portion and, 4, as follows, 1135-5.5-103. Definitions. As used in this article Article 5.5, 12 unless the context otherwise requires. 13, 4, Commissioner means the Commissioner of the Department 14 of Agriculture or his or her the Commissioner's designee. 15 Section 24. In Colorado Revised Statutes, 35-5.5-107, amend 16, 3, as follows, 1735-5.5-107. Local Advisory Board, formation, duties. 3 each. 18 Local Advisory Board shall annually elect a chairman, chair, and secretary. 19 A majority of the members of the board shall constitutes a 20 quorum for the conduct of business. 21 Section 25. In Colorado Revised Statutes, 35-5.5-108.7, 22 amend, 1, e, as follows, 2335-5.5-108.7. State Noxious Weed Advisory Committee, repeal. 24, 1e, a quorum of the State Advisory Committee shall elect or appoint 25 annually a chairman chair and a vice chairman vice chair. 26 Section 26. In Colorado Revised Statutes, amend 35-7-110 as 27 follows. Dash 15, 1084. 135-7-110. State reimbursed for actual cost. All poisons or other materials for such control furnished by the state to such cooperators shall 3 be supplied at actual cost, and the state shall be reimbursed by such 4 cooperators, landowners, lessees, or contract holders for the actual cost 5 of materials and labor, other than supervision, expended by the state in 6 such treatment under cooperative agreements with them. Such 7 reimbursement shall be made by each owner, lessee, or contract holder in 8 the proportion that the number of acres of land treated for him or her the 9 owner, lessee, or contract holder bears to the total acreage treated 10 in the area designated for treatment or according to such equitable 11 proportion or plan as shall be provided for in the agreement. Any such 12 agreement must require full reimbursement to be made to the state 13 within 30 days after presentation by the department, or its agents, of an 14 itemized account. Therefore, 15 Section 27. In Colorado Revised Statutes, 35-7-112, amend 16, 2, as follows, 1735-7-112. Eradication contracts required, procedure without 18 contracts. 2. If the owner, after 10 days written notice to him the 19 owner in person or by mail to his the owner's last known post office 20 address, fails, neglects, or refuses to reimburse the department, or its 21 agents, in the amount of such the expenses incurred by the 22 department, the department shall certify an itemized statement thereof 23 of the expenses, together with a description of such lands the land 24 sufficient to identify the same land to the Board of County Commissioners 25 of the county wherein in which the same land is situated. Thereupon, 26 such and after the department certifies the itemized statement, 27 the account shall be audited, allowed, and paid in like manner as. 16, 1084. 1 provided in section 35-7-110. Public notices in a public notice 2 published for the purposes of this section provided for shall must 3 designate as accurately as may be the boundaries of the area to be treated, for shall make specific reference to this statute, and shall call upon all 5 owners, known or unknown, of lands within the prescribed area to 6 proceed at once to destroy the pests mentioned in such the notice or to 7 enter into cooperative agreements for their control or eradication, and 8 shall designate reasonable times and places within or near such the area 9 where and when and where the federal agency, or other agents, and the 10 department, or its agents, will be present for the purpose of entering into 11 such cooperative agreements and proceeding with their execution. 12 Section 28. In Colorado Revised Statutes, amend 35-7-114 as 13 follows, 1435-7-114. Charges against landowner, lien rights. Whenever 15 any a county has been required to pay any an expense charged against 16 any landowners a landowner, under a cooperative agreement or 17 otherwise, on account of such pest control operations conducted upon or 18 for the benefit of his or her the landowner's lands. Such the county 19 shall have as a lien upon such the lands for the amount so paid or for 20 such lesser amount as such the landowner shall be adjudged to pay 21 after a hearing before the Board of County Commissioners. 22 Section 29. In Colorado Revised Statutes, amend 35-7-115 as 23 follows, 2435-7-115. Enforcing collection, hearing. Upon payment by any 25A county of any such a bill of expenses so charged against any A26 landowner, lessee, or contract holder, the Board of County Commissioners 27 shall make demand and notice in writing upon such the landowner. 17, 1084. 1 lessee, or contract holder, in person or by mail addressed to him or her at to his or her the landowner, lessee, or contract holder at the 3 landowners, lessees, or contract holder's last known place of 4 residence, 20 days prior to the published meeting date for 5 reimbursement to the county in the amount of such the expenses. Such 6 the written notice shall must inform such the person that he or she the 7 person may appear before the board on the published meeting date and 8 be heard as to the amount and accuracy of the claim. If such the claim, 9 as originally demanded by the board or as adjusted upon the hearing, is 10 not paid, then, in the case of a private landowner, the Board of County 11 Commissioners shall certify the claim to the county assessor who shall add 12 the amount thereof of the claim to any taxes due or to become due upon 13 his or her the person's lands, and said the lands shall be sold for the 14 satisfaction thereof of the claims at the same time and in the same 15 manner as is provided by law for the sale of real estate for delinquent 16 taxes. In cases where such the accounts are payable by a lessee or 17 contract holder, suit may be maintained in behalf of the county in any A18 court of competent jurisdiction for the recovery of such the accounts and 19 costs of suit. All such accounts when collected by the county shall be paid 20 into the general fund thereof of the county or into the fund used by the 21 county to meet its obligations under this Part 1. 22 Section 30. In Colorado Revised Statutes, amend 35-7-116 as 23 follows, 2435-7-116. Collections paid to treasurer. All reimbursements to 25 the state, whether made by individuals, counties, or other cooperators 26 pursuant to this Part 1, shall be turned over to the state treasurer and by 27 him to be credited to the Rodent Pest Control Fund referred to created in 18, 1084. 1 Section 35-7-103. 2 Section 31. In Colorado Revised Statutes 35-9-103, amend 3, 5, and 10 as follows. For 35-9-103. Definitions. As used in this Article 9, unless the context 5 otherwise requires. 6, 5, device means any instrument or contrivance, other than a 7 firearm, intended for trapping, destroying, repelling, or mitigating any A8 pest or any other form of plant or animal life, other than man humans and 9 other than bacteria, viruses, or other microorganisms on or in living man 10 humans or other living animals, except that device shall does not 11 include equipment used for the application of pesticides. When sold 12 separately therefrom from a device. 13.10 Pest means any insect, rodent, nematode, fungus, weed, or 14 other form of terrestrial or aquatic plant or animal life or virus, bacteria, 15 or other microorganism, except viruses, bacteria, or other microorganism 16 on or in living man humans or in other living animals, which that the 17 Commissioner or the Administrator of the EPA declares to be a pest. 18 Section 32. In Colorado Revised Statutes 35-9-108, amend 19, 2, 5, introductory portion, 6, introductory portion, and 7, as follows. 2035-9-108. Registration, review and evaluation, criteria, state 21 limited use or restricted use pesticide, cancellation, summary 22 suspension. 2. If the Commissioner determines that the pesticide, the 23 labeling, or any other materials submitted with the end application do not 24 comply with the provisions of this article, this Article 9, the 25 Commissioner shall notify the applicant of the particulars in which their 26 is a lack of compliance. 27. 5. The Commissioner, in the Commissioner's discretion. 19, 1084. May 1st, at the time of registration, designate the A pesticide as a State 2 restricted use or limited use pesticide and may restrict or limit the 3 distribution or use of such the pesticide. The Commissioner may include 4 in said the restriction the time and conditions under which the pesticide may 5th be distributed or used and may impose any or all of the following 6 additional requirements. 7. 6. After a pesticide is registered, the Commissioner may cancel 8 the registration of said the pesticide pending notice and an opportunity 9 for hearing if the Commissioner determines that. 10. 7. If the Commissioner has reasonable grounds to believe and 11 finds that the A registrant has been guilty of deliberate and willful 12 violation of use or distribution restrictions imposed pursuant to this Article 13 Article 9 or that the public health, safety, or welfare imperatively 14 requires emergency action, the Commissioner may summarily 15. Suspend the registration pending proceedings for suspension or 16. Cancellation of the registration. 17. Section 33. In Colorado Revised Statutes 35-9-111, amend 18, 1, introductory portion as follows. 1935-9-111. Device registration, application, fees, expiration 20, rules. 1. Each applicant for registration of a device shall file with the 21 Commissioner, in the form and manner the Commissioner shall 22 designate, 23 Section 34. In Colorado Revised Statutes 35-9-112, amend 24, 3, introductory portion and 4, as follows. 2535-9-112. Renewal of pesticide and device registration, fees. 26, 3. The Commissioner may require the applicant to submit any additional 27 information the Commissioner deems necessary, including, but not. 20, 1084. 1 limited to, 2, 4. The Commissioner, at the time of such the renewal of A3 registration, may, in his at the Commissioner's discretion, designate for any such a pesticide as a state restricted use or limited use pesticide in 5 the same manner as set forth in Section 35-9-108, 5. 6 Section 35. In Colorado Revised Statutes 35-9-115, amend 7, 4, as follows. 835-9-115. Pesticide dealer license, requirements, application 9, fees, expiration. 4. Each licensee shall report to the Commissioner. 10. In the form and manner the Commissioner shall designate. 11. Designates any change to the information provided in such the 12 licensee's application or in such the reports previously submitted within 15 days of such after the change. 14. Section 36. In Colorado Revised Statutes 35-9-118, amend 15, 2, introductory portion and 2, c, I, as follows. 1635-9-118. Powers and duties of the Commissioner, exemptions. 17. Rules. 2. The Commissioner is authorized to may adopt all reasonable. 18. Rules for the administration and enforcement of this Article. Article 9, 19 including, but not limited to, 20, c, I, adopting a list of restricted use pesticides or limited use 21 pesticides for the state or designated areas within this the state if the 22 Commissioner determines that such pesticides require rules restricting 23 their distribution or use. The Commissioner may include in the rule the 24 time and conditions of the distribution or use of such restricted use or 25 limited use pesticides and may require that any such pesticide be 26 purchased, possessed, or used only under permit of the Commissioner and 27 under the Commissioner's supervision. The Commissioner may 21, 1084. 1. Require all persons issued such permits to maintain records regarding the use of such pesticides. 3. Section 37. In Colorado Revised Statutes 35-9-119, amend 4, 1, 2, b, and 3, as follows. 535-9-119. Investigations, access, subpoena. 1. The 6th Commissioner, upon the Commissioner's own motion or upon the 7 complaint of any person, may make any and all investigations necessary 8 to ensure compliance with this article. Article 9. 9. 2b. The Commissioner shall have full authority to may 10th administer oaths and take statements, to issue administrative subpoenas. 11. Requiring the attendance of witnesses before him the Commissioner, and 12. The production of all books, memoranda, papers, and other documents, 13. Articles, or instruments, and to compel the disclosure by such witnesses 14. Of all facts known to them relative to the matters under investigation. 15. Upon the failure or refusal of any a witness to obey any a subpoena, the 16. Commissioner may petition the district court, and, upon a proper showing. 17. The court may enter an order compelling the witness to appear and testify. 18. Or produce documentary evidence. Failure to obey such an order of the 19th court shall be punishable as a contempt of court. 23. Complaints of record made to the Commissioner and the results 21 of the Commissioner's investigations may, in the discretion of the 22 Commissioner, be closed to public inspection, except as provided by Court 23 order, during the investigatory period and until dismissed or until notice 24 of hearing and charges are served on a licensee or registrant. 25. Section 38. In Colorado Revised Statutes, 35-9-120, amend 26, 2, introductory portion and 2c, as follows, 2735-9-120. Prohibited acts, deceptive trade practice. 2, it is. -22, 1084. 1. Unlawful and a violation of this article. Article 9. For any pesticide dealer. 2, c, to permit the use of the pesticide dealer's license by 3 persons to whom the license was not issued, for Section 39. In Colorado Revised Statutes, 35-9-121, amend 5, 1, 2a, 2b, I, and 3, as follows, 635-9-121. Enforcement, cease and desist orders, hearings. 7, 1, the Commissioner or the Commissioner's designee shall enforce 8 the provisions of this article. This Article 9. 9, 2a, whenever the Commissioner has reasonable cause to 10 believe a violation of any a provision of this article. Article 9 or any A11 rule made adopted pursuant to this article. Article 9 has occurred and 12 immediate enforcement is deemed necessary. He the Commissioner may 13th issue a cease and desist order, which may require any a person to cease 14 violating any a provision of this article. Article 9 or any a rule made 15 adopted pursuant to this article. Such Article 9. The cease and desist. 16 order shall must set forth the provisions alleged to have been violated. 17. The facts alleged to have constituted the violation, and the requirement. 18. That all actions be ceased forthwith. 19. b, I, at any time after service of the order to cease and desist. 20. The person may request, at the person's discretion, an immediate 21 hearing or a hearing not more than 10 days, excluding Saturdays, 22 Sundays, and legal holidays, after such request to determine whether a 23 violation has occurred. Such hearing shall be conducted pursuant to the 24 provisions of Article 4 of Title 24. CRS. 25. 3. Whenever the Commissioner possesses evidence satisfactory. 26. To him the Commissioner that any a person has engaged in or is about 27 to engage in any an act or practice constituting a violation of any A-23, 1084. 1 provision of this article. Article 9 or of any a rule adopted under this 2 article. Article 9, the Commissioner may apply to any a court of 3 competent jurisdiction to temporarily or permanently restrain or enjoin the 4 act or practice in question and to enforce compliance with this article. 5. Article 9 or any a rule adopted under this article. Article 9. In any such 6 action, the Commissioner shall not be required to plead or prove 7 irreparable injury or the inadequacy of the remedy at law. Under number 8 circumstances shall the court require the Commissioner to post a bond. 9. Section 40. In Colorado Revised Statutes, 35-9-123, amend 10, 4, and 5, as follows, 1135-9-123. Embargo, penalty. 4. When a pesticide or device 12 detained or embargoed under subsection 2 of this section has been 13 found by the Commissioner to be in violation of any provision of this 14 article. Article 9 or any rule promulgated adopted pursuant to this. 15. Article 9 and if the violation has not been resolved in 30 days. 16. The Commissioner may petition a court of competent jurisdiction for a 17 condemnation of such pesticide or device. When the Commissioner has 18 found that a pesticide or device so detained or embargoed is not 19 adulterated or misbranded, he the Commissioner shall remove the tag or 20 other marking. 21. 5. If the court finds that a detained or embargoed pesticide or 22 device is in violation of this article. Article 9 or rules adopted thereunder. 23. Such pursuant to this Article 9, the pesticide or device shall after 24 entry of the decree be destroyed at the expense of the owner, claimant, or 25 custodian thereof of the pesticide or device, under the supervision of 26 the Commissioner, and all court costs and attorney fees and storage and 27 other proper expenses shall be assessed against the owner, claimant, or -24, 1084. 1 custodian of such the pesticide or device or the owner's, 2 claimants or custodian's agent. However, if the adulteration or 3 misbranding can be corrected by proper labeling or processing of the 4 pesticide or device, the court, after entry of the decree and after such 5 costs, attorney fees, and expenses have been paid and a good and 6 sufficient bond has been executed, conditioned upon the proper labeling 7 or processing of such pesticide or device, may by order direct that such 8 the pesticide or device be delivered to the owner, claimant, or custodian 9 thereof for such labeling or processing under the supervision of the 10 Commissioner. The expense of such supervision shall be paid by the 11 owner, claimant, or custodian. The pesticide or device shall be returned 12 to the owner, claimant, or custodian of the pesticide or device on the 13 representation to the court by the commissioner that the pesticide or 14 device is no longer in violation of this Article 9 and that the 15 expenses of such supervision have been paid. 16 Section 41. In Colorado Revised Statutes, 35-10-103, amend 17, 5, and 9, as follows, 1835-10-103. Definitions. As used in this Article 10, unless the 19 context otherwise requires, 25, device means any instrument or contrivance, other than a 21 firearm, intended for trapping, destroying, repelling, or mitigating any 22 pest or any other form of plant or animal life, other than man humans and 23 other than bacteria, viruses, or other microorganisms on or in living man 24 humans or other living animals, except that device shall does not 25 include equipment used for the application of pesticides when sold 26 separately therefrom from a device. 27, 9, pest means any insect, rodent, nematode, fungus, weed, or -25, 1084. One other form of terrestrial or aquatic plant or animal life or virus, bacteria, 2 or other microorganism, except viruses, bacteria, or other microorganisms 3 on or in living man humans or in other living animals, which that the commissioner or the administrator of the EPA declares to be a pest. 5 Section 42. In Colorado Revised Statutes, 35-10-106, amend 6, 1, C, and 3A, as follows, 735-10-106. Commercial applicator, license requirements, 8 application, fees. 1. As requisites for licensure, the applicant for a 9 commercial applicator business license shall, 10, C, provide verifiable training to all technicians in his the 11 applicants employ according to standards adopted by the Commissioner. 12, 3A. If a commercial applicator operates under more than 113 business name from a single location, the commercial applicator 14 shall list the name of each such business providing services related to 15 pesticide application shall be listed with the Commissioner in the form. 16 and manner he shall designate designated by the Commissioner. The 17 Commissioner may require that a separate fee be paid for each business 18 names so listed. 19 Section 43. In Colorado Revised Statutes, 35-10-110, amend 24, as follows, 2135-10-110. Registered limited commercial and registered 22 public applicators, requirements for operation. 4. If the 23 Commissioner, pursuant to Section 35-10-109, establishes a registry of 24 limited commercial and public applicators, he or she the Commissioner may 25th also require that each registered applicator report, in the form and 26 manner the Commissioner shall designates, any change to the 27 information provided by such the applicator to the registry or in any such. 26, 1084. 1. Reports previously submitted within 15 days after said the change. 2. Section 44. In Colorado Revised Statutes, 35-10-112, amend 3, 1b, as follows, 435-10-112. Notification requirements, registry of 5 pesticide-sensitive persons, preemption, rules. 1b. The 6th Commissioner shall provide standardized notification signs to any person 7 accepted for the registry for such the person to post on his the person's 8 property. These signs shall be designed, manufactured, and distributed 9 solely by the Department. 10 Section 45. In Colorado Revised Statutes, 35-10-115, amend 11, 1a, 1c, and 3, as follows, 1235-10-115. Qualified supervisor, certified operator, and 13 private applicator licenses, examination, application, fees. 1. Each 14 applicant for a qualified supervisor, certified operator, or private 15 applicator license shall, 16a, pass a written examination in each class or subclass of 17 pesticide application, or device use, in which he or she the applicant 18 wishes to be licensed. 19, c. If he the applicant wishes to be licensed to engage in aerial 20 application of pesticides, possess a certificate issued by the Federal 21 Aviation Administration as specified in license qualifications adopted by 22 the Commissioner. 23, 3. Each licensee shall be required to report to the Commissioner. 24. In the form and manner he shall designate the Commissioner. 25. Designates any change to the information provided in such the 26 licensee's application or in any such reports previously submitted within 15 days of such after the change. 27, 1084. 1 Section 46. In Colorado Revised Statutes, 35-10-116, amend 2, as follows, 335-10-116. Qualified supervisor and certified operator licenses for, expiration, renewal of licenses, reinstatement. 2. A licensee 5 licensed pursuant to Section 35-10-115 may have the option to apply to 6 renew a license without further examination if he the licensee has 7 completed, within the previous 3 years, the competency requirements 8 established by the Commissioner. 9 Section 47. In Colorado Revised Statutes, 35-10-117, amend 10, 3, introductory portion, 3a, 3c, 2, and 5, as follows, 1135-10-117. Unlawful acts, deceptive trade practice. 3. It is 12 unlawful and a violation of this article Article 10 for any a commercial 13 applicator, qualified supervisor, or certified operator, 14, a, to permit the use of the commercial applicators, 15 qualified supervisors, or certified operators licensed by any other 16 person. 17, c. 2, if a commercial applicator receives instructions from a 18 party contracting for such the applicator's services and the commercial 19 applicator knows or should know that using the device or applying the 20 pesticide in the manner specified by the contracting party may not or does 21 not meet generally accepted standards for such use or application, the 22 commercial applicator must shall so inform the contracting party. If the 23 contracting party, after being so advised, continues to require the 24 commercial applicator to perform the application or use the device 25 according to these instructions, the commercial applicator may follow 26 these instructions for such the application or use unless such the 27 application or use would violate any of the directions contained on the 28, 1084. 1 pesticide or the device or the labeling of either or would violate any 2 provision of this article Article 10 or Article 9 of this Title 35 or any 3 rule or regulation adopted pursuant to this Article 10 or Article 9(4) of this Title 35. If the commercial applicator complies with these 5 requirements, the party contracting for such the application of any 6 pesticide or use of any device shall have has no cause of action for 7 damages against the commercial applicator if the application or use 8 causes death or injury to the contracting party or the contracting 9 party's property or is unsatisfactory in its result, unless the contracting 10 party establishes, by a preponderance of the evidence, that such death, 11. Injury, or unsatisfactory result resulted from negligence or an intentional 12 act not encompassed within or necessitated by the instructions provided 13 by such the contracting party. 14.5. It is unlawful and a violation of this Article 10 for any 15 employee or official of the department to disclose or use for the 16 employees or officials' own advantage any information derived from 17 any applications, reports, or records, including medical records, submitted 18 to the department pursuant to this Article 10 or to reveal such 19 information to anyone except authorized persons, who may include 20 officials or employees of the state, the federal government, the courts of 21 this or other states, and physicians. 22 Section 48. In Colorado Revised Statutes, 35-10-119, amend 23, 2, 3, and 5, as follows, 24 35-10-119. Inspections, investigations, access, subpoena. 25, 2, the Commissioner, upon the Commissioner's own motion or 26 upon the complaint of any person, may make any and all investigations 27 necessary to ensure compliance with this Article 10. 29, 1084. 1, 3. Complaints of record made to the Commissioner and the results 2 of the Commissioner's investigations may, in the discretion of the 3 Commissioner, be closed to public inspection, except to the person in for interest, as defined in Section 24-72-202, 4, CRS, or as provided by 5 court order, during the investigatory period and until dismissed or until 6 notice of hearing and charges are served on a licensee. 7, 5. The Commissioner shall have full authority to may administer 8 oaths and take statements, to issue subpoenas requiring the attendance of 9 witnesses before him the Commissioner and the production of all books, 10 memoranda, papers, and other documents, articles, or instruments, and to 11 compel the disclosure by such witnesses of all facts known to them 12 relative to the matters under investigation. Upon the failure or refusal of 13 any a witness to obey any a subpoena, the Commissioner may petition the 14 District Court, and, upon a proper showing, the Court may enter an order. 15. Compelling the witness to appear and testify or produce documentary 16 evidence. Failure to obey such an order of the court shall be is punishable 17 as a contempt of court. 18 Section 49. In Colorado Revised Statutes, 35-10-120, amend 19, 1, and 3, as follows, 2035-10-120. Enforcement. 1. The Commissioner or the 21 Commissioners designee shall enforce the provisions of this article 22 Article 10. 23, 3. Whenever the Commissioner possesses sufficient evidence 24 satisfactory to him the Commissioner indicating that any a person has 25 engaged in or is about to engage in any an act or practice constituting a 26 violation of any a provision of this Article 10 or of any a Rule 27 adopted under this Article 10, the Commissioner may apply to any 30, 1084. 1. A court of competent jurisdiction to temporarily or permanently restrain to or enjoin the act or practice in question and to enforce compliance with 3. This Article 10 or any rule or order adopted under this article for Article 10. In any such action, the Commissioner shall not be required 5 to plead or prove irreparable injury or the inadequacy of the remedy at 6 law. Under no circumstances shall the court require the Commissioner to 7 post a bond. 8 Section 50. In Colorado Revised Statutes, 35-10-125, amend 9, 2, introductory portion and 2a, as follows, 1035-10-125. Advisory Committee. 2. The Advisory Committee 11 is a state public body, as that term is defined in Section 24-6-402, 1d, 12 CRS, and consists of the following members, 13, a formulator, or a formulator's Colorado representative, 14 actively engaged in the sale of pesticides in Colorado, 15 Section 51. In Colorado Revised Statutes, 35-11-102, amend 16 the introductory portion, 4, and 12, as follows. 1735-11-102. Definitions. As used in this Article 11, unless 18 the context otherwise requires. 19, 4. Contamination means the degradation of natural water 20 quality as a result of man's human activities. 21.12. Pollution means the man-made, human-made, or 22 man-induced, human-induced alteration of the physical, chemical, 23 biological, or radiological integrity of water. 24. Section 52. In Colorado Revised Statutes, 35-11-105, amend 25.2, as follows, 2635-11-105. Issuance of provisional chemigation permit, fees. 27.2, an applicant for a provisional chemigation permit shall, on the -31-1084. 1 application, certify that the irrigation system for which he the applicant 2 is seeking a permit includes properly installed and functioning equipment. 3 in compliance with section 35-11-107. 4 section 53. In Colorado Revised Statutes, 35-11-106, amend 5.2, as follows, 635-11-106. Issuance of chemigation permit, fees. 2. The N7 applicant for a chemigation permit shall, on the application, certify that 8. The irrigation system for which he the applicant is seeking a permit 9 includes properly installed and functioning equipment in compliance with 10. The provisions of section 35-11-107. Upon receipt of a permit, the permit 11 holder shall attach, in a prominent place, the permit to the irrigation 12 system for which the permit was issued. 13. Section 54. In Colorado Revised Statutes, 35-11-111, amend 14.2 and 3, as follows, 1535-11-111. Inspections, entry upon land. 2. Prior to an 16 inspection, the inspector shall notify a permit holder of the time and date. 17. Of the inspection. The inspector shall inform the permit holder that he 18 is entitled to the permit holder may be present at the inspection. If a 19 permit holder denies access to an inspector, the inspector may seek an 20 inspection warrant issued by the district court for the district in which the 21 permit holder's land is located. The court shall issue such the inspection 22 warrant upon presentation by the inspector of an affidavit stating, 23a, the information which that gives the inspector reasonable 24 cause to believe that any provision of this Article 11 is being 25 violated or has been violated, or the information showing that such the 26 entry and inspection is required in order to determine whether the 27 provisions of this article are this Article 11 is being complied with, as -32-1084. 1. The case may be, 2b, that the inspector notified the permit holder of an inspection, 3c, that the inspector was denied access by the permit holder, and 4d, a general description of the location of the affected land. 5.3. Each irrigation system subject to the provisions of this Article 6 which this Article 11 that has not been issued a permit pursuant to the 7 provisions of this article may 11th be inspected, without prior 8 notice, by an inspector who has information which that gives him the 9 inspector reasonable cause to believe that any provision of this Article 10 Article 11 is being violated. If the landowner denies access to the 11 inspector, the inspector may seek an inspection warrant issued by the 12 district court for the district in which the landowner's land is located. The 13 district court shall issue such inspection warrant upon presentation by an 14 inspector of an affidavit stating 15a, the information which that gives the inspector reasonable 16 cause to believe that any provision of this Article 11 is being 17 violated or has been violated, 18b, that the landowner has denied access to the inspector, and 19c, a general description of the location of the affected land. 20. Section 55. In Colorado Revised Statutes, amend 35-14-106 21 as follows, 2235-14-106. Administration. The Commissioner shall administer 23 and enforce the provisions of this article and shall have in this Article 24:14 and may exercise any and all of the administrative powers conferred 25 upon the head of a department of the state. The Commissioner is 26 authorized to may employ, pursuant to Section 13 of Article 12 of the 27 State Constitution, such deputies and inspectors as he may deem the -33-1084. 1 Commissioner deems necessary for the proper enforcement of this Article. 2 Article 14, subject to the Constitution and laws of the state. The powers 3 and duties given to and imposed upon the Commissioner are also given to 4 and imposed upon the deputies and inspectors when acting under the 5 instructions and at the direction of the Commissioner. 6 Section 56. In Colorado Revised Statutes, 35-14-107, amend 7, 1k, and 1m, as follows, 835-14-107. Powers and duties of Commissioner, rules. 1. The 9 Commissioner shall, 10k, approve for use, and may mark, such weights and measures 11 as he or she the Commissioner finds to be correct and may reject, and 12 mark as rejected such weights and measures as he or she the 13 Commissioner finds to be incorrect. Weights and measures that have 14 been rejected may be seized if not corrected within the time specified, or 15 if used or disposed of in an unauthorized manner. The Commissioner may 16 condemn and seize weights and measures that are found to be incorrect. 17 and that are not capable of being cannot be made correct. 18m. Prescribe the appropriate term or unit or weight or measure 19 to be used whenever he the Commissioner determines, in the case of a 20 specific commodity, that an existing practice of declaring the quantity by 21 weight, measure, numerical count, or combination thereof of weight, 22 measure, or numerical count does not facilitate value comparison, or 23 is represented in any manner that tends to mislead or deceive any person. 24 Section 57. In Colorado Revised Statutes, 35-14-108, amend 25, 1, introductory portion, 1a, 1d, and 2, as follows, 2635-14-108. Special police powers. 1. When necessary to 27 perform his duties or to implement the provisions of this article this. 34, 1084. 1. Article 14 or the rules and regulations promulgated adopted pursuant to thereto to this Article 14, the Commissioner or the Commissioner's 3 authorized agent may, 4. A. Enter any commercial premises during normal business hours, 5. Except that, in the event such premises are not open to the public, he the 6th Commissioner shall first present the Commissioner's credentials and 7. Obtain consent before making entry thereto unless a search warrant has 8. Previously been obtained, 9. D. Stop any commercial vehicle and, after presentment of the 10 Commissioner's credentials, require that the person in charge of the 11 vehicle produce any documents in the person's possession 12 concerning the contents of said the vehicle, inspect the contents of such 13 the vehicle at the site, and, if necessary, require such the person to 14 proceed with the vehicle to some specified place for inspection. 15. 2. The Commissioner may administer oaths and take statements. 16. Issue subpoenas requiring the attendance of witnesses before him or her. 17. The Commissioner and the production of all books, memoranda, papers, 18. And other documents, articles, or instruments, and compel the disclosure 19. By such witnesses of all facts known to them relative to the matters under 20 investigation. Upon the failure or refusal of any a witness to obey any A21 subpoena, the Commissioner may petition the District Court, and, upon a 22 proper showing, the Court may enter an order compelling the witness to 23 appear and testify or produce documentary evidence. Failure to obey such 24 an order of the Court shall be punishable as a contempt of court. 25. Section 58. In Colorado Revised Statutes, amend 35-14-11026 as follows, 2735-14-110. Misrepresentation of quantity. No a person shall. 35, 1084. 1. Not sell, offer, advertise, or expose for sale less than the quantity of 2 commodity or service he the person represents nor take any more than 3 the quantity of commodity or service he the person represents. 4. Section 59. In Colorado Revised Statutes, 35-14-121, amend 5, 3, 4, 6, introductory portion, 6, A, and 6, B, as follows, 635-14-121. Weigher, qualification, certification, revocation 7, rules. 3. The Commissioner may adopt rules for determining the 8 qualifications of the applicant for a license as a certified weigher. For 9. The purpose of determining qualifications of the applicant, the 10 Commissioner may approve the qualifications of the applicant upon the 11 basis of the information supplied in the application or he the 12 Commissioner may examine such the applicant orally or in writing or 13 both. He the Commissioner shall grant certificates of certified weigher 14 to such applicants as may be found to possess the qualifications required. 15. By subsection 1 of this section. The Commissioner shall keep a record. 16. Of all such applicants and of all certificates issued. 17. 4. The Commissioner may, upon request and without charge, 18. Issue a limited certification as a certified weigher to any qualified officer 19. Or employee of a municipality or county of this state or of a state 20 commission, board, institution, or agency authorizing such officer or 21 employee to act as a certified weigher only within the scope of the 22 officers or employees' official employment. 23. 6. The following persons shall be permitted, but shall not be 24 required, to may obtain certification as certified weigher. 25. A weights and measures officer when acting within the scope 26 of the officer's official duties. 27. B. A person weighing property, produce, commodities, or articles. 36, 1084. 1. That he the person or the person's employer, if any, is buying or 2 selling, and 3. Section 60. In Colorado Revised Statutes, 35-14-122, amend 4, 6, A, as follows, 535-14-122. Public scales, requirements, weight certificates, 6. Procedures, records. 6. A. All commodities bought, sold, delivered, 7. Or in the process of changing ownership that use the weight of the content 8. For final determination and settlement shall be weighed on a scale 9 licensed in accordance with this article. Article 14. If neither the buyer 10 nor the seller owns his or her own a scale, the weigher shall issue a 11 weight certificate containing all the information required by subsection 12, 2, of this section to both the buyer and the seller. If the buyer or seller 13 owns his or her own a scale licensed by the department and uses such the 14 scale to determine the weight of such the commodities, such the party 15 shall issue a ticket or invoice in duplicate to the other party. Said the 16 ticket or invoice shall must contain all the information required by 17 subsection 2 of this section. 18. Section 61. In Colorado Revised Statutes, 35-14-131, amend 19, 5, A, as follows, 2035-14-131. Civil penalties. 5. It is a violation for any person to, 21, sell, offer, or expose for sale or hire, or have in his or her the 22 person's possession for the purpose of selling or hiring an incorrect 23 weight or measure or any device or instrument used or calculated to 24 falsify any weight or measure. 25. Section 62. In Colorado Revised Statutes, 35-14-132, amend 26, 1, as follows, 2735-14-132. Criminal penalties. 1. Any person who willfully. 37, 1084. 1 makes, installs, sells or offers to sell, or uses or allows to be used on his to or her the person's weights or measures any a counterfeit seal, or seal 3 of the Commissioner without proper authority, commits a civil infraction for and shall be punished as provided in Section 18-1.3-503. 5 Section 63. In Colorado Revised Statutes, 35-14-133, amend 6, 3, as follows, 735-14-133. Enforcement, cease and desist orders, hearings. 8, 3, whenever the Commissioner possesses sufficient evidence 9 satisfactory to him or her the Commissioner indicating that a person has 10 engaged in or is about to engage in an act or practice constituting a 11 violation of this article Article 14 or any a rule or order adopted 12 pursuant to this article Article 14, the Commissioner may apply to a court 13 of competent jurisdiction to temporarily or permanently restrain or enjoin 14 the act or practice in question and to enforce compliance with this article. 15 Article 14 or any a rule or order adopted pursuant to this article Article 16-14. In any such action, the Commissioner shall not be required to plead 17 or prove irreparable injury or the inadequacy of the remedy at law. Under 18 no circumstances shall the court require the Commissioner to post a bond. 19 Section 64. In Colorado Revised Statutes, amend 35-23-10320 as follows, 2135-23-103. Federal Cooperation. The Commissioner is 22 empowered to of Agriculture may enter into such agreements with the 23 United States Department of Agriculture as he the Commissioner may 24th determine to be necessary or advisable for the establishment of a joint 25 state and federal inspection service in Colorado for fruits, vegetables, and 26 other agricultural products. 27 Section 65. In Colorado Revised Statutes, amend 35-23-105. 38, 1084. 1 as follows, 235-23-105. Authority to enter business places. In carrying out 3 the provisions of this Article 23, the Commissioner of 4 Agriculture and his the Commissioner's deputies, inspectors, and 5 employees are authorized to may enter on any business day, during the 6 usual hours of business, any storehouse, warehouse, cold storage plant, 7 packing house, or other building or place where fruits, vegetables, or 8 other agricultural products are kept or stored by any person engaged in the 9 shipping of fruits, vegetables, or other agricultural products or to stop or 10 inspect at any time any automobile, truck, trailer, or other vehicle 11 transporting or containing any such fruits, vegetables, or other 12 agricultural products. 13 Section 66. In Colorado Revised Statutes, amend 35-23-10614 as follows, 1535-23-106. Establishment of regulations and grades, public 16 meetings. The Commissioner is empowered to may establish and enforce 17 such grades, grading rules, and regulations in addition to those established. 18 by this article Article 23, in no event less than the minimum 19 requirements prescribed by this article Article 23, as he the 20 Commissioner may deem necessary on fruits, vegetables, and other 21 agricultural products, which shall not conflict with any provisions of this 22 article this Article 23, after a thorough investigation has been made of 23 the needs of the particular fruit, vegetable, or other agricultural product 24 for which grades, grading rules, and regulations are contemplated, but 25 whenever it is deemed advisable by the Commissioner, such grades shall 26 be the same as the grades promulgated by the United States Department 27 of Agriculture. Such grades, grading rules, and regulations, before they 39, 1084. 1 become effective, shall be submitted for approval at 1 or more public 2 meetings called for that purpose and attended by representative growers 3 and shippers of the localities interested in the industry affected. Such 4 meetings shall be advertised at least once in a newspaper published in 5 such localities, 1 week or more prior to the meeting. Said each 6 meeting shall be presided over by the Commissioner or any of his the 7 Commissioners duly authorized deputies and, insofar as possible and 8 practicable, shall be conducted at such places as can be conveniently 9 reached by representatives of the affected industry. Grades, grading rules, 10 and regulations, established in accordance with the provisions of this 11 section, shall not be modified during the current shipping season of the 12 fruit, vegetable, or other agricultural product for which they are 13 established. In like manner the Commissioner may provide for standard 14 packages for all fruits, vegetables, and other agricultural products, but no 15 standard packages shall not be eliminated or changed without 2 years 16 notice to the industry involved. 17 Section 67. In Colorado Revised Statutes, amend 35-23-10818 as follows, 1935-23-108. Rules. The Commissioner of Agriculture, with the 20 concurrence of the State Agricultural Commission, is authorized to 21 promulgate such may adopt rules and regulations relative to the proper 22 marking of containers, the issue of certificates of inspection, and the 23 tagging of the vehicle of transportation and such other rules and 24 regulations as he the Commissioner deems necessary for the 25 improvement of the quality of marketing of all fruits, vegetables, or other 26 agricultural products. 27 Section 68. In Colorado Revised Statutes, amend 35-23-109. 40, 1084. 1 as follows, 235-23-109. Engaging in trade prohibited. The Commissioner of 3 Agriculture and the Commissioner's deputies, inspectors, and 4 employees are each prohibited, during their respective terms of 5 employment or office, from engaging in this state or elsewhere, either 6 directly or indirectly, in the business of buying or selling fruits, 7 vegetables, or other agricultural products or in dealing in the same on 8 Commission. 9 Section 69. In Colorado Revised Statutes, amend 35-23-11210 as follows, 1135-23-112. Appeal of Inspection, Rules. Any and interested party 12 who is dissatisfied with any classification of grades of any fruits, 13 vegetables, or other agricultural products made as the result of inspection 14 under this article Article 23, within such time after the inspection and in 15 such manner as shall be prescribed by the Commissioner of 16 Agriculture, may appeal to the Commissioner, and the Commissioner is 17 directed to promulgate shall adopt rules and regulations governing the 18 time and manner of such appeal. Upon such appeal to him being regularly 19 taken the Commissioner shall cause such 20 investigation to be made and such tests to be applied as he the 21 Commissioner may deem necessary to determine the true grade or 22 classification in the particular case in question and shall issue a finding 23 determining the true grade or classification in the particular case. 24 Whenever an appeal to the Commissioner is taken, he the Commissioner 25 shall fix and assess, and collect, or cause to be collected, the established 26 fee for an original inspection for each such appeal, which shall fee must 27 be uniform and which shall be refunded to the person paying the same if. 41, 1084. 1. The findings of the Commissioner on appeal are to the effect that the grade 2 or classification as determined and certified on the original inspection 3 was erroneous and a new or different grade or classification is determined 4 by the Commissioner. Any reinspection certificate issued as the result of 5 an appeal shall supersedes the original inspection certificate. 6. Section 70. In Colorado Revised Statutes, amend 35-23-1157 as follows, 835-23-115. Information Confidential, Rules. All information 9 obtained as the result of any an inspection made under the provisions of 10 this article 23 shall not be open to inspection by the public. 11 Except that the Commissioner of Agriculture shall prepare and certify 12 to any financially interested party a copy of the original inspection 13 certificate of any inspection upon the payment to him of his fees therefore 14 the Commissioner of any required fees. The Commissioner is 15 authorized to may prescribe rules and regulations governing the issuance 16 of such certificates. 17 Section 71. In Colorado Revised Statutes, 35-24.5-104, 18 amend, 2, and 3, as follows, 1935-24.5-104. Aquaculture Board, created, members. 2. The 20 term of office of the 2 additional members shall be appointed IN 21 subsection, 1b, of this section IS 3 years. Each of these members 22 additional members shall serve until his or her the additional 23 member successor has been appointed and qualified, and either member 24 shall be IS eligible for reappointment. They both additional members 25 shall serve without compensation except for actual and necessary 26 traveling expenses. 27. 3. The board shall annually select a chairman chair and a 42, 1084. 1 vice chair, who may be the same as the chairman chair 2 and vice chair of the Fish Health Board. 3. Section 72. In Colorado Revised Statutes, 35-25-103, amend 4, 1, 2, a, 4, 5, d, and 6, as follows, 535-25-103. Enforcement. 1. The Commissioner or the 6 Commissioners authorized agents are authorized and directed to enforce 7 the provisions of this article Article 25. 8. 2a. If it appears to the Commissioner after examination of the 9 facts that a violation of any provision of this Article 25 has 10 occurred, he the Commissioner may refer the facts to the District 11 Attorney for the county in which the violation occurred. 12. 4. The Commissioner may, by publication in such manner as he 13 the Commissioner may prescribe, give notice of all judgments entered 14 in actions instituted under the authority of this Article Article 25. 15. 5d. Whenever the Commissioner is found to have lacked 16 substantial justification to impose a civil penalty, the person charged may 17 recover the person's costs and attorney fees from the Department of 18 Agriculture. 19. 6. The Commissioner shall have full authority to may administer 20 oaths and take statements, to issue subpoenas requiring the attendance of 21 witnesses before him the Commissioner and the production of all books, 22 memoranda, papers, and other documents, articles, or instruments, and to 23 compel the disclosure by such witnesses of all facts known to them 24 relative to the matters under investigation. Upon the failure or refusal of 25 any a witness to obey any a subpoena, the Commissioner may petition the 26th District Court, and, upon a proper showing, the Court may enter an Order 27 compelling the witness to appear and testify or produce documentary. 43, 1084. 1. Evidence. Failure to obey such an order of the court shall be is punishable 2 as a contempt of court. 3. Section 73. In Colorado Revised Statutes, 35-25-105, amend 4, 2, as follows, 535-25-105. Rules. 2. The powers and duties of the Commissioner 6 under this article Article May 25 be delegated by the Commissioner to 7 employees of the Department of Agriculture designated by him the 8th Commissioner. 9. Section 74. In Colorado Revised Statutes, 35-25-106, amend 10, 1, as follows, 1135-25-106. Examination of apiaries. 1. The Commissioner. 12. When he the Commissioner has reason to suspect disease in any apiary, May 13th examine all reported or suspected apiaries. If any a contagious 14 disease is present, he the Commissioner may examine all apiaries in the 15 same locality and ascertain whether or not any a contagious disease exists 16 in the apiaries. If satisfied of the existence of any such a contagious 17 disease, the Commissioner may burn, sterilize, or medically treat said 18 apiary in strict compliance with rules and regulations pertaining thereto. 19. Or the Commissioner may require the beekeeper to burn, sterilize, or 20 medically treat said the apiary. 21. Section 75. In Colorado Revised Statutes, amend 35-25-10722 as follows: 2335-25-107. Inspection of beehives for interstate movement. 24. Any a beekeeper or person requesting an inspection of beehives for 25 contagious disease for the purpose of interstate movement shall be IS 26 liable for all costs of such inspection. The beekeeper or his the 27 beekeepers agent shall accompany and assist the inspector in making the -44, 1084. 1. Inspection. 2. Section 76. In Colorado Revised Statutes, 35-26-105, amend 3, 2, as follows: for 35-26-105. Prohibited acts, removal from sale, advisory 5 alerts. 2. The Commissioner or his the Commissioner's authorized 6 agents shall issue a stop sale order to any person offering nursery stock 7 for sale in violation of any provision of this article, Article 26, or any 8 rules or regulations promulgated adopted pursuant to this article. Any 9. Article 26. A person receiving a stop sale order shall remove such stock 10 from sale immediately. 11. Section 77. In Colorado Revised Statutes, 35-26-108, amend 12, 2, as follows: 1335-26-108. Access to locations and records, administrative 14 subpoena, complaints and investigations. 2. The Commissioner, upon 15 his the Commissioner's own motion or upon the complaint of any 16 person, may make any and all investigations necessary to ensure 17 compliance with this article, Article 26. 18. Section 78. In Colorado Revised Statutes, 35-26-110, amend 19, 1.5, as follows: 2035-26-110. Out-of-state nurseries. 1.5. An out-of-state nursery 21 advertising and selling nursery stock in Colorado and having no duly 22 appointed resident agent in this state upon whom process may be served 23 as provided by law shall be deemed to have appointed the Secretary of 24 state as the agent of said the nursery upon whom service of process may 25th be had in the event of any suit against said the nursery. Service on the 26th Secretary of State of any such process shall be made by delivering to and 27 leaving with him the Secretary of State or with his the Secretary. -45, 1084. One of State's deputy, an assistant, or a clerk 2 copies of such process. The 2 Secretary of State shall also require a statement which that contains the 3 name and address of the non-resident's home or home office. After receipt 4 of such process the Secretary of State shall forward to the defendant a 5 copy of the process by registered mail, return receipt requested. The 6th person so serving the Secretary of State shall immediately send or give to 7 the Commissioner a notice of such service and a copy of the process. The 8th Secretary of State shall collect at the time of any service of process on him 9 the Secretary of State as resident agent a fee which that shall be 10 determined and collected pursuant to Section 24-21-104, 3. CRS. 11. Section 79. In Colorado Revised Statutes, amend 35-26-11112 as follows: 1335-26-111.
Representative
Rules.
Bradley.
Thank
The
you, Madam
Commissioner is
Speaker.
hereby
I would like to
authorized and
stop
for-
having the bill be read at length. Thank you.
The request has been withdrawn. The bill will not be read at length. Members, we are on 3rd reading of bills. The motion before us is the passage of House Bill 1084 on 3rd reading and final passage. Mr. Schiebel, please open the machine, and members proceed to vote. Representative Brooks, how do you vote?
Yes.
Representative Brooks votes yes. Representatives Leader, Story, Valdez excused. Please close the machine. With 48 aye, 15 no, and 2 excused, House Bill 1084 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1023.
House Bill 1023 by Representatives Martinez and Bacon, also Senators Gonzalez and Simpson, concerning local government review of certain fencing projects.
Madam Majority Leader.
Madam Speaker, I move House Bill 1023 on third reading and final passage.
Representative DeGraff.
Thank you, Madam Speaker. I think this is a really interesting bill, as I've learned a lot more about the treaties that were in place when the land was brought over from the Spanish colonies, and I'm very sympathetic to that. I'm not really sure that all of the avenues that are available to the counties have been exhausted. And there's also the implication from the witness testimony that this is something that is really what I'd say a problem in looking for a solution and saying, hey, we want to have this fencing requirement all across the state. Here's a problem, and now we're going to take this problem, we're going to take it to the legislature as a matter of process to say, we would like you guys to be the easy button and solve our problem for us, but in their doing, creating a statewide precedent. And the statewide precedents that are created out of here have long-term ramifications. And talking to various other ranchers that have fences that might be similar, there can be reason for these fences. I was as a safety officer and in charge of the wildlife mitigation for the safety of an entire airport. Learned a lot about that with deer, that we had to have to keep deer in or out. We had to have about a 20-foot fence all the way around, because anything lower, the deer could pretty much just jump over at will. And you had to test all of the gaps in it with they would test the gaps in it with a tennis ball, that basically any gap bigger than a tennis ball that the deer would be able to squeeze themselves through. So, I'm not saying I agree with the rancher who's building this out. I think there is the level of nuisance and violation, but I would think that the county could also present a lien against the fence, and possibly against the contractors if they are violating a cease and desist order. Again, I think this is going to be a bad precedent, create a bad precedent to solve a singular problem, and we need to be really, really careful about overstepping. Now, I know we're not, but I think we should be. And this is an area where I think we should have a little bit more consideration, because while we personally don't see the need for this fence, there are others that do have a need for this fence because they make this type of fence, and maybe there's some other solutions. But this body being the easy button for everybody's problems across the state, and then imposing a statewide solution that's going to have negative consequences that we do not know. And at that point, when it has consequences that we didn't step back to consider, then we need to consider those consequences as being, intentional. So anyways, I would vote no on this bill. I think there's a lot more we don't know about it than we do know about it. I'm sympathetic to the idea. I'm sympathetic to the county or the municipality that is dealing with this. But I think there's some other options that they can pursue rather than creating a precedent that is statewide.
Representative Martinez.
Thank you, Madam Speaker. It's an honor to serve with you.
It is an honor to serve with you.
Members, I wanted to add a little bit more context on the bill that we're discussing now from yesterday. So this piece of land, we've had disputes for over 150 years on this piece of land, dating back before Colorado was Colorado. When we moved from a territory to a state, Colorado honored this specific land grant, the Sangre de Cristo land grant, in their communal use for livestock, or to graze livestock, hunt fish, gather firewood on what we call La Sierra. And this is guaranteed by the 1848 Treaty of Guadalupe Hidalgo. When we moved into a state, a lot of these other land grants were not honored, but this one was. And why? Because the people, you've heard me say this a lot here, that this is like the people here have been in this area for generations, dating back to the early Spanish colonial days in this area. And so Colorado recognized those rights to this property, to being able to do communal grazing, hunting, and fishing. This has been challenged since then. And this is a continual fight that we've had to fight. We've had to continue to bring this up. So this is not new, and this is not unprecedented. It took a Supreme Court case, Colorado Supreme Court case in 2002 to uphold those rights for the land grantees to being able to access this property. So this is not uncommon in the state of Colorado for this particular plot of land. I also want to say with this, because of that, and the best way to look at this is, it is an easement. Every owner since then, since the 1960s, when this has gone into private hands, has well understood this right for the land grantee descendants to have access to this property and to work in harmony with the community. That is not what has been happening as of late. When we're looking at this, and if any members are interested, I'm happy to share this with you all and invite you down to the district to see this. The amount of damage that has been done because of this is excruciatingly painful. You hear me talk about this a lot in this building. Water is life in the valley. What is happening? Because we are ripping out natural vegetation in the area, it is causing new floodplains that have been caused, that's causing sediment to go into our irrigation ditches, into our water table. We're also splitting up deer and elk herd that are vital and crucial to our way of life in southern Colorado. Also, again, what did I say before? This is a guidance from the Colorado Supreme Court and law that we have here in the state to live in harmony with the landowner and the community. And that is probably the biggest piece that we have here with rising tensions that have continued to occur in this area. This is a local control bill, and I want to reiterate that. This is a local control bill. All this bill does is require the person putting up a fence in the Sangre de Cristo land grant area, that is it, it's not statewide, it is in the Sangre de Cristo land grant area, to seek a permit for approval from their local county. We talk a lot about local control in this area. That is what this does. It gives the county more power to do this. I've gotten questions, why do we need this? Why does this need to come up? Because the county has tried to deal with this in their own way and have so far been unsuccessful. This gives them that additive boost to make the decisions that are best for their own communities and to make those decisions at the local level without state involvement. I'll close with this. We can talk about affordability, we can talk about transportation, we can talk about housing in this chamber, and those are great things. And these types of conversations need to be included in that. I've said this many times before. Life happens outside of the metro area. Life happens in my district. This is something that has been going on for 150 years. And this is what the basis of public policy is, to bring issues that our constituency bring up and have issues with and looking for additive support. So today I ask for you to stand with Coloradans, the oldest Coloradans that have been here in this state, and to support local control. I urge and I vote.
Representative DeGraff, this is your second time to speak. You have 6 minutes and 6 seconds remaining.
Thank you, Madam Speaker. That's great. Like I said, I'm not sympathetic to the sympathetic to the rancher's cause. I'm not sympathetic to what he's doing. What I'm trying to not do is make another law. We have a Supreme Court ruling that says that he needs to remove the fence, that he needs to honor the treaty that goes back to the Spanish colonies. He needs to, and that's all fantastic. He has court orders. And so what we're going to do is we're going to say somehow magically out of this room, we are going to make a law that says they can do what they've been actually doing this entire time. Well, there's a Supreme Court ruling that says that he is in the wrong. So why do we need another law? It seems like we're looking at an enforcement mechanism, and lacking that enforcement mechanism, we're going to make another law. Now, do we have any idea whether this person is going to honor this law? Why would this law be honored when the other laws were not, when the other determinations by the Supreme Court were not? I get it. Water is life. We would probably do better on the grasslands by having more grazing instead of limiting it. Like we're doing. But when you say this is a local control bill, this is a bill for a specific locality to do what they need to do. I get that, but this is a bill that has statewide ramifications. When you say we want to be able to have do this without state involvement, this looks a lot like state involvement. So when I look around and we're at the State General Assembly, we're looking at state involvement. We're looking at saying the General Assembly needs to step in. Well, the Colorado Supreme Court has already stepped in. The Colorado Supreme Court has already stepped in and said, you must honor this treaty. And so now we're going to add another law, another layer of law, which is not benign because it will always have ramifications outside of this specific area. There's no way to contain the effects of this law to this specific rancher. The way to contain the law, the treaty, to this specific rancher is the way it's been done with law enforcement. Now, why we have law enforcement? We have the Colorado Supreme Court saying this is the law to be enforced. Why do we have law enforcement and the Colorado Supreme Court saying enforce this law and there's no enforcement? That's the problem. We don't need more laws. We need a proper application. So this is state involvement. This is state involvement making a law for that will be, if it can be weaponized against you, it will be weaponized against you. If this can be weaponized against the state of Colorado, it will be weaponized against the state of Colorado. This will be misused. It'll be used, whether misused or not, it'll be used as intended across the state of Colorado for effects that we don't know. Because we don't stop and consider how is this going to spread outside of the intent. And I guarantee you it will spread outside of the intent. Because the witness testimony said we want it to spread outside the intent. And the intent being this specific rancher. So this body needs to stop being the easy button for legislative warfare for people to impose their will on other people. We have a law. We have the Supreme Court saying that is the law, enforce the law. Now we have a problem with our law enforcement. So not the need for another law. I would like to know why this law has not been enforced and how another law is going to help. So I'm against this bill because I think it's an incredible amount of mission creep. It encourages legislative warfare. It encourages everybody to come here to push the easy button and get a piece of legislation done. And we see it time after time, and this is another example. I think this is another good intention, and we know where those lead too often.
Seeing no further discussion, the motion before us is the adoption of House Bill 1023 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Brooks, how do you vote?
No.
Representative Brooks votes no. Please close the machine. With 45 aye, 19 no, and 1 excused, House Bill 1023 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1053.
House Bill 1053 by Representatives Morrow and Weinberg, also Senators Marchman and Baisley, concerning limited immunity for civil liability for landowners who allow access to their property for entry and exit in connection with an emergency.
Madam Majority Leader.
Madam Speaker, I move House Bill 1053 on third reading and final passage.
Seeing no discussion, the motion before us is the third reading, final reading, and final passage of House Bill 1053. Mr. Shebel, please open the machine and members proceed to vote. Representative Brooks, how do you vote?
Yes.
Representative Brooks votes yes.
I told him.
Please close the machine. With 64 aye, 1 excused, House Bill 1053 is adopted. Co-sponsors. Please close the machine. Madam Majority Leader.
Madam Speaker, I move the following bills be made special orders on February 6, 2025 at 10:44 a.m. House Bill 1027, House Bill 1009, and House Bill 1138.
Seeing no objection, the bills listed by the Majority Leader will be made special orders on February 6th, 2025 at 10:44 a.m. Representative Mabry. Members, you have heard the motion. Seeing no objection, Representative Mabry will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request to have a bill read at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the majority leader, and the coat rule is relaxed. Mr. Schiebel, please read the title to House Bill 1027.
House Bill 1027 by Representatives Gilchrist and Brown, also Senator Doherty, concerning modifications to statutes governing disease control.
Thank you, Mr. Chair.
Representative Gilchrist.
Thank you, Mr. Chair. I move House Bill 1027 and the committee report.
To the committee report.
In the committee, we passed an amendment that made some changes that I want to discuss briefly. In the stakeholdering of this bill, we heard from Immunize Colorado, Children's Hospital, and the American Academy of Pediatrics that they were concerned about the provision of the bill extending the amount of time given to a parent or a student to come into compliance with vaccine requirements. So the bill was set at 14 days, no less than 14 days, and we changed it to 30 days. We believe this allows families to have the flexibility in getting their children vaccinated and has a little bit more time. At this time, we will offer a series of amendments. I move L009 to the committee report and ask that it be properly displayed. And I can go ahead.
Okay, so they have them.
All right, that is a proper motion. That amendment is properly displayed. To the amendments. Representative Gilchrist.
Thank you, Mr. Chair. L009, L010, and L011 all address the same issue. These amendments solve a problem brought to us by the Colorado Camps Network, which is a network of overnight camps hosting kids from Colorado from out of state. Current statute requires all campers to be vaccinated. If the camper is from out of state, our statute requires the camp to transcribe the camper's official immunization record from their home state to Colorado's immunization forms. However, almost all state immunization forms mirror Colorado's forms, so this requirement is unnecessarily burdensome for camp staff.
Is there any further discussion on Amendment L9? Seeing none, the motion before us is the adoption of Amendment L9. All in favor say aye.
Aye.
All opposed say no. Amendment L9 is adopted. To the committee report.
I have to move the next one.
Representative Gilchrist.
Thank you, Mr. Chair. I move L010 to the committee report and ask that it be properly displayed.
Good job.
All right, that is a proper motion and that is properly displayed. To the amendment, Representative Brown.
Thank you, Mr. Chair. This amendment follows L009, and again, it makes changes based on the changes that we are making for the based on our conversations with camps and reducing the administrative burden. It introduces this new definition that we have added that will help to reduce administrative burden, and we ask for an aye vote on the amendment.
Is there any further discussion on Amendment L10? Seeing none, the question before us is the adoption of Amendment L10 to House Bill 1027. All those in favor say aye.
Aye.
All opposed say no. Amendment L10 is adopted. To the committee report. Representative Gilchrist.
Thank you, Mr. Chair. I move L011 to the committee report and ask that it be properly displayed.
That is properly displayed. To the amendment, Representative Brown.
Thank you very much, Mr. Chair. Again, this amendment just is more conforming amendments to additional parts of the bill that help to deal with this particular issue that some of our Colorado camps have when dealing with vaccination records from out-of-state students. We ask for an aye vote.
Is there any further discussion on Amendment L11? Seeing none, the motion before us is the adoption of Amendment L11 to House Bill 1027. All those in favor say aye. All opposed say no. Amendment L11 is adopted. To the committee report. Representative Gilchrist.
Thank you, Mr. Chair. I ask for an aye vote to the committee report.
Is there any further discussion on the committee report? Seeing none, the motion before us is the adoption of the committee report to House Bill 1027. All those in favor say aye. All those opposed say no. The committee report is adopted. To the bill. Representative Gilchrist.
Thank you, Mr. Chair. Members, I'm honored to be in front of you today to present House Bill 251027 to update disease control statutes. This bill will improve how the state responds to disease outbreaks and other emergencies. Our public health system has a lot of lessons learned from our numerous response events over the past several years. Now we have an opportunity with this bill to accomplish some administrative cleanup and regulatory streamlining that can even further improve our state's response to public health emergencies. This bill does a few things. It repeals the Governor's Expert Emergency Epidemic Response Committee, the GERC, and allows better results and better coordination through the use of existing authorities. It also currently, the state statute restricts which healthcare providers can create an immunization record, and physicians' assistants are not included in that. This bill would change that. Another burden to families is the fact that the state statute currently limits how long student has to come into compliance with the school entry immunization requirements. This is the amendment we discussed earlier, moving the 14-day period to the 30-day period. And then finally, and equally as important, the bill also seeks to align Hep C screening requirements to the CDC's latest recommendations, allowing for more people to get screened for Hep C and more people to get care. And I ask for your yes vote today.
Representative Brown.
Thank you, Mr. Chair, and I'm pleased to be able to join my colleague from Denver on this particular piece of legislation, which will help to modernize our disease statutes, reduce burden for families. At this time, I move L015 to House Bill 1027.
All right, that's a proper motion, and the amendment is displayed. To the amendment, Representative Gilchrist.
Thank you, Mr. Chair. L015 removes the ability of the State Board of Health to review and approve CDPHE's internal emergency response and recovery plan, and instead allows the board every 3 years to approve and amend the plan as necessary. And I ask for a yay vote.
Representative Brown.
Thank you, Mr. Chair. This was based on a technical issue that we had with the initial introduced version of the bill. We caught it after committee, so we're just introducing this amendment to clarify the original intent of the bill. We ask for an aye vote.
Is there any further discussion on Amendment L15? Seeing none. The question before us is the adoption of Amendment L15. All those in favor say aye. Aye. All those opposed say no. Amendment L15 is adopted. To the bill. Representative Brown.
We ask for an aye vote on the bill.
Is there any further discussion on House Bill 1027? Representative Johnson. Representative Johnson.
Thank you, Mr. Chair. So I was a yes vote in committee, and I am coming up today that after consideration with my constituents, more ongoing stakeholdering process, and having more time to look through everything that's going on with this, it is a mess of a bill. It doesn't do enough for parental rights, while it does have a step to parental rights, and I am going to withdraw my support and be voting no. While in committee, I did like that it did have, due to instances like COVID control was taken from the committee and given back to the governor, who is accountable to the voters, rather than a committee that has no accountability and takes direction directly from the governor. I also liked how it extended the time frame for vaccination reporting from 14 to 30, and I really did like the hepatitis C expansion. However, there is blatant flaws with this. It does undermine some parental aspects, and it is too convoluted and pushed through too fast that I am going to be a strong no vote.
Is there any further discussion on House Bill 1027? Representative Johnson.
Mr. Chair, I would like to move L006 to House Bill 1027. and ask that it be properly displayed.
That is a proper motion. That is properly displayed. To the amendment, Representative Johnson.
Thank you, Mr. Chair. This amendment is striking the safety clause and moving it to petition clause. Something that has this much impact on families, parents, and children needs to be able to be heard by the body of Colorado. We need to allow them that 90-day grace period so they have the chance to petition. Safety clauses are way overused in this state to bypass the will of the people and to limit their voice. So let's give them the voice and move to petition. I urge a yes vote on this amendment.
Is there any further discussion on Amendment L6? Representative Weinberg. No. Representative Brown.
Thank you, Mr. Chair. And first off, thanks to my colleague from the Eastern Plains for her thoughtful discussion and for making sure that voters in Colorado are always included. We ask for a no vote on this amendment. In this particular case, there are requirements and changes to the way that schools administer the vaccine forms and requirements that are necessary to be in place prior to this effective date in a petition clause. So it would delay the flexibility that families have in order to comply with vaccination requirements, and so we ask for a no vote.
Representative Weinberg.
Thank you, Mr. Chair. I rise in support of this amendment. I urge that we all take it very serious when it comes to listening to the people in our state. Requiring a 90-day period for people to actually have an opinion and a say on matters such as important as this. We need to give everybody an opportunity to understand and review what we as legislators are doing in this building. I rise in support of this amendment, and I urge an aye vote.
Is there any further discussion? Representative DeGraff.
Thank you, Mr. Chair. We're not in an emergency, and I get that this is dealing with a pre-emergency, but given the gross buffoonery of how the last pandemic was handled, I think this needs a little bit more public input. Gross buffoonery. That's how we'd respond to it. That's how we'd reply to, describe it militarily. The gross overreach by the government in this regard, and the overreach that this bill is really trying to codify. We're talking about a lot of different moving parts, and they affect the people of Colorado. So yeah, we want to have a way to deal with emergencies, but we need to have a way to deal with emergencies that support the oath that we have taken to the people of Colorado. And that oath is that to secure these rights, among which are life, liberty, and the pursuit of happiness, governments are instituted among men, deriving their just power from the consent of the governed. This bill has a lot of impositions. This bill has a lot of circumventions around consent of the governed. It really doesn't matter how much a Karen cares more than everybody else. It does not justify violating the oath that the people are individually sovereign. A safety clause is a way to circumvent this even more, because the First Amendment guarantees the right of the people to petition their government for the redress of grievances. So if they have a grievance with this bill, then they should be able to redress that with government. They should be able to petition the government. The purpose of the safety clause is so that they cannot petition government. Article 5, Section 1, Paragraph 3 states that the legislation passed for the immediate, not future, immediate. So words mean things. Immediate does not mean future. Preservation of the public peace, health, or safety is exempt from the power of the referendum to overturn it by either signed petition of registered electors or the General Assembly. So what is this petition for? What is this safety clause for? To prevent referendum, to prevent the power of the referendum to overturn this bill or by signed petition of registered electors or the General Assembly. This safety clause is to circumvent the people of Colorado for whom we are supposed to protect their rights. There's nothing in the state constitution that says it's our job to take care of everybody. And in fact, if you look at the response on the COVID response, probably the deadliest part of the COVID response was the experts. And I will show you that a little later. Well, I won't show you because
Representative
you're not allowed to.
DeGraff, could you please keep it to the amendment? I believe this is about the petition clause.
This
and
is.
not the pandemic. So if you could please go back to the petition clause.
That's exactly where I was trying to go, Mr. Chair, so thank you. So
Okay,
colleagues,
good,
this is
good.
an end around, an abridgment of our First Amendment, that Congress shall make no law respecting an establishment, religion, or prohibited in the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. You all took an oath on day one to support that document. You all pledge allegiance to the flag. Well, most of you do. Most of us do. But that supports these values of the United States of America. That we are here to protect the rights of the people, not to impose our version of how much we care more than everybody else. This bill is a circumvention of that. I don't know what the sponsor, other than caring more than everybody else, has not given a justification for violating the right of the people to petition government in regards to this bill. This bill is about government
Representative
overreach.
DeGraff, could you please not impugn the motives of our colleagues? And please keep it to the petition clause. If you want to speak to the bill, you can, but this is about the Amendment L6.
No, sir, I want to speak about the petition clause and how each of us in this room took an oath to uphold the Constitution of the United States and the Constitution of Colorado. And governments are instituted among men, deriving their just power from the consent of the governed. And this is an end run around the consent of the governed. It is a violation of the respect for the governed. This is a violation of the respect for the governed, that they can take care of themselves. This is more overreach by the nanny state. The safety clause is in overreach by the nanny state. This law is about taking each individual one by one into the powerful hands of government and molding him as it pleases. It's about a sovereign power extending the arms over the entire society, covering it with a network of small, complicated, minute, and uniform rules which most original minds and the most vigorous of souls cannot break through or go beyond. These laws do not break wills, but soften them, bends them, and directs them to reduce them to a nation of nothing more than a flock of timid and industrious animals to which the government is the shepherd. This safety clause is the government saying to the people of Colorado, we know better than you. Despite all the evidence to the contrary, this body determines with the safety clause, we know better than you. That's what the safety clause is saying. We do not trust you. We do not trust you with your health. We do not trust you with your children. We, the General Assembly of Colorado, will take that out of your hands. We are not elected to impose our good intentions for some greater good. That never is. We are to only execute the just powers to which the governed would consent. We're not called here to govern. We're not called here to make rules, a series of minute and uniform rules spread across the people of Colorado. We are here to represent the rights of Colorados, not just to represent the rights of Coloradans, but to secure those rights of Coloradans. If we're afraid to present a law for consideration by the governed, absent some truly emergent reason to preserve the public peace, health, or safety, it should be assumed to be in opposition of the consent of the governed. If you're going to violate the consent of the governed, you're violating your oath. I move that the safety clause be removed. I move that we accept this amendment. Now, what is the likelihood that there will be a petition? Well, probably very low. It's probably very low. Historically, it's very low. But that does not justify an abuse of the safety clause. So I recommend an aye vote for good governance to remove this abuse of the people of Colorado, remove the safety clause, replace it with a petition clause, have some respect for the people of Colorado who put you here, that maybe they can govern their own lives and that we should get back to preserving their rights instead of figuring out ways to bulldoze over them. So for the people of Colorado, for the respect of our Constitution, please vote no on the safety clause, yet vote yes on this amendment to remove it.
Representative Soper.
Well, thank you, Mr. Chair. Members, I rise in support of the amendment. There's nothing in the bill that would indicate why there shouldn't be a petition clause. And it's really important to understand why we have a petition clause. You know, Article 5, Section 1(3) of the Colorado Constitution reserves the right of petition to the people to be able to put something on the ballot for approval, which was passed by the legislature. So that's the general rule. The safety clause is actually the exception to that rule. And there's only two reasons for why you'd have a safety clause. One is because your budget is at stake, or the other one is for the health, safety, and welfare of the state. Given the title, one might argue that the second clause within the exception would be covered here, because the title of the act is concerning modifications to statutes governing disease control. However, as you read House Bill 1027, you realize that in fact, there's nothing in the proposed bill that needs to take effect right away. Everything that's being proposed here could actually be delayed until that August date, which is about 90 days after the legislature has adjourned. Much here is also rulemaking by the various departments responsible, like CDPHE. I guarantee you that will take time as well. So there is nothing as I look at the bill that is going to require that it needs to be effected immediately. And because of that, this is a great amendment. It's one that honors our Constitution, and it's important to do so. And I would encourage a yes vote. Thank you.
Is there any further discussion on Amendment L6? Seeing none, Representative Weinberg.
Thank you, Mr. Chairman. Again, fellow colleagues, I urge, and I vote on this, the importance of the job that we hold in this chamber is to the people that we are responsible for, the 88,000 people that choose to put us in these chambers are being ignored when we rush straight into safety clauses. We all need to look to make sure that our constituents are understanding of what this language actually does. This is good governance, and I would urge everybody, if your constituents were in front of you right now or in your ear, would they be satisfied with the no vote? Now, we know that the petition clause hasn't been passed in this state in many years, which in my opinion would be the exact reason why we would put this on. Give people a chance to digest what we're doing. Give people a chance to have an opinion. Because I would beg to argue that if this went before the voter, they would vote it down. I urge, and I vote.
Is there any further discussion? Members, the committee will stand in a brief recess. A division has been called. The committee will come to order. A division had been called. Members, just to clarify where we're at. A division has been called on Amendment L6. I did see one or two more Republican members who did want to speak to this amendment. We can complete debate on this amendment and then go to the division if Representative Kelty wanted to speak to this amendment. Representative Kelty.
Thank you, Chair, for allowing me to speak. I know I'm the new person on the block. From what I understand, the petition clause is something that we should all probably want because we want everyone to have a say into what we're doing. I know that we're elected, but our constituents still have a voice. By putting the petition clause in there, it allows them to further express their voices. And I think that this should never, ever, ever be muted. I believe in the First Amendment, and I believe that that is what this supports. And I hope that we can get an aye vote on this so we can show the people of Colorado that we really do care about what they feel and what they say. Thank you.
Is there any further discussion on Amendment L6? Representative Clifford.
I'm hearing a lot of conversation about the petition clause this year. We're going to be looking into how many times that's been used in the last 20 years. I think it's like 1.
Is there any further discussion? Representative DeGraff.
Thank you, Mr. Chair.
Representative DeGraff.
Yeah, it's my turn. Piggy has the
I
conch.
had recognized him. Yeah. Representative DeGraff.
Thank you, Mr. Chair. I think we should have a conch. I think that would be appropriate if we had a conch. A shell, a giant shell. If you've read Lord of the Flies, that you would recognize that reference. That's an excellent point from my colleague that it has been used probably once. That would make for a typical government study to waste a whole lot of time, probably not a whole lot of time, but waste any time on such a study. So here's the point. We have a petition clause to allow the people of Colorado to exercise that right. So if you're not afraid of the people doing that, then really you shouldn't do a safety clause at all. But you should allow the people of Colorado to have the opportunity. You need to allow the people of Colorado to have the opportunity. Now, most likely, as I said before, most likely the people of Colorado will not, because the people of Colorado cannot possibly keep up with all the unconstitutionality that goes on in the bill mill. We churn out regulations, and the people of Colorado just sit back there and say, I can't even keep up. We overrule, we step outside the consent of the governed 700, probably 600 times a year. And this is just another example of stepping outside. So not only are we stepping outside the consent of the governed, not only are we looking at a bill that wants to impose mandates which are in violation of the consent of the governed, despite all scientific evidence. What we want to do is we want to then say to the people of Colorado, you don't even have the opportunity. You don't even have the opportunity to appeal what this body does. We are going to eliminate that because that is how little we think of your opinion. Now, the bill mill clearly thinks very little of the opinion of Colorado, but this is just a heightened example of how little.
Representative DeGraff, if
Yes,
you
sir.
could not impugn the motives of our colleagues, please.
Sir, I don't know
To
the
the
motives
amendment.
of our colleagues. I don't know the motives of our colleagues.
Okay, well, do not impugn the motives of our colleagues, please, in the interest of decorum and respecting one another. You can speak about the amendment.
The amendment is an effort to at least acknowledge to the people of Colorado, to try to say to the people of Colorado that yes, we know the likelihood of you exercising this right is very low. But we do respect you enough to at least give you the opportunity. So I won't impugn the motives of any other of my colleagues, but I will respect the motives of my colleagues that say we must honor the ability, the concerns, the considerations of our constituents. We were not brought here to govern. You were not put in these chairs to govern. You were not put in these chairs to tell people how to run their lives. You were put in these chairs to represent the rights of your constituents, among which are life, liberty, and the pursuit of happiness. I don't know why that is so difficult, but this amendment is intended to get us back on track with honoring the oath that we took on day one. We need to honor the oath that we took on day one, and that is to the people of Colorado to uphold their rights, not figure out ways to legislate them away by the nanny state. This is a good amendment. The abuse of the safety clause is an abuse of the citizens of Colorado. Because if everything is an emergency, nothing is an emergency. This is not an emergency. This is a bad bill, but we'll get to that. So vote yes on this amendment to respect the people of Colorado.
AML Winter.
Thank you, Mr. Chair. I also urge an aye vote on this amendment. I'm actually shocked that my colleague from Centennial came up here and said that they want to make legislation veto-proof by the people. That's what the petition clause is. This allows people to air their grievances. If we get rid of the petition clause, this is a rubber stamp. The people should have the right to air their grievances. So what? It's been used one time. How many times do you use the fire extinguisher in your house? But it's there when you need it. I urge an aye vote for the people.
Minority Leader Puglisi.
Thank you, Mr. Chair. I'm trying to find the good representative from Arapahoe County. So I, as a private citizen in 2019, used the petition clause to launch the largest grassroots movement in Colorado's history. 2,500 people who signed a petition to override the legislature. And while we weren't ultimately successful, all of those people were able to get their voices heard and stand up and say, no, we don't like what you have done, legislature. So to silence the voices of all of those people, all of the people who were engaged on either side of that issue is just wrong. So I take issue with the fact that it is hard to run a ballot initiative like this, but it is also important to give that voice and that option to the people and not take it away. I urge an aye vote. Thank you.
Representative Hartsook.
Good morning. Thank you, Mr. Chair. You know, back when they wrote the Constitution, the first one obviously was the First Amendment. And the reason we had that is so that people would have a voice. I find it grossly arrogant to say we don't need something like that just because it's only been used once. I don't care if it's been used once, 100 times, 1,000 times, 10,000 times. It's the right of the people. Whether they choose to exercise that right or not is upon them. It certainly is not our job here in this body to deny them that right. We should not be pushing through pieces of legislation that bypass the opportunity of the people to petition. Because at what point does that stop? If this body suddenly seems to think that, oh, maybe I should just start skipping this for the citizens and that for the citizens, when and where does it stop? They wrote that in the First Amendment for a reason. We have it in our Constitution for a reason. And we should never bypass that. except in maybe extreme emergencies of life or death when you need to use the safety clause. The petition should be the standard clause, even if it had only been used once. Doesn't matter. It's still the right of the people. And our job is to protect their rights. I urge an aye vote. Thank you.
Members, a division has been requested. Representative Johnson.
Thank you, Mr. Chair. To the comment that this is the people's house, we are a people state. We are here serving and working for the people. We are the voice of the people. To say we're taking the option away so they cannot have that voice because it's only happened one time is outrageous. It infuriates me because we are representing all of our constituents with pride, and we need to be respectful that all of them should have the choice to opt into that voice, to have the petition. It should not be taken away because it has not been used. It's the same thing of saying no one should have access to 911 because they never had to call it. They should have that right to be heard, and even though they're not using it, they deserve that right to be at the table, should they choose to be able to have a voice in their house, in their legislation, in something that affects the entire state. And I want to make sure that we are preserving that right because we are their voice. We are not their blocker. We cannot stop them from the voice that they have the right to have. It is on them. I believe in freedom over force. If they do not want to use it, that is on them, but we should not, as a collective body, take that right away from them.
Members, the question before us is the adoption of Amendment L6. A division has been requested. All those in the chamber not entitled to vote, please be seated. All those in favor of Amendment L6, please stand and remain standing or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing or raise your hand until the count is taken. Amendment L6 is lost. To the bill. Representative Bradley. Representative Garcia Sander.
Thank you, Mr. Chair. I made a mistake. We all make mistakes sometimes. And I voted yes initially in committee, and I would like to change that to a no. I spoke with some of my constituents, and I'm from Weld County. And local control matters a lot in Weld County. I'd like to see assurance that counties and county commissioners reserve and are granted their local control on addressing disaster and public health emergencies. Thank you.
Representative Bradley.
Thank you, Mr. Chair, and thank you, members. I would like to explain why I had the first bill read at length. I did not bring forth amendments in this committee because the bill sponsors had talked about having a meeting with me. So you can imagine my surprise when the very next day this bill was put on special orders calendar. So if I'm not gonna have a seat at the table, we're gonna listen to a lot of bills for a very long time. First problem with this bill, because there's some really good qualities of this bill, and I appreciate the bill sponsors for really looking into this. I see where they're coming from, and I see where they're trying to make this a little bit better, but for the constituents that we represent, the districts that we represent, we're still reeling from COVID and the way it was handled in this state. We're still very angry at how COVID was handled in this state. And so now, in response to that, we're going to take away a committee of people that meet, a 19-member committee that meets that helps respond to this crisis, and we're going to put it in the hands of the governor and CDPHE. Wow. Local public health officials are best situated to make decisions and adopt and enforce public health orders based on their expertise and knowledge of local communities. Rural Colorado didn't have the same problems with COVID that urban Colorado had. So why as a state are we regulating everyone to do the same thing? We closed 38% of small businesses down. That's how they handled the pandemic. And now, in the spirit of efficiency, we're asking to remove a 19-member group that advised the governor on what to do in a public emergency. That was epidemiologists, that was emergency room physicians, that was bringing a bunch of people to the table. Because to be quite honest, I feel like we've been in a syphilis crisis for 20 years in this state. We just keep shelling out money, so we ain't doing that very good. So why remove this body of people that would provide critical oversight of decisions made by the governor and public health officials during a time of emergency? And now we're just going to assemble a group of subject matter experts. I don't even know what that means. And I asked the bill sponsors to work with me on this, and nothing. Who are the subject matter experts? And why are we not defining it? We define it with everything else. We pull task force, we have the majority leader assigned, we have the Speaker of the House assigned, and now we just have assemble a group of subject matter experts. So I have a major problem with that. Why are we not bringing local businesses and communities and rural representatives and urban representatives and economists and people like that to the table to help us in this crisis when we're shutting down 38% of businesses? Why are we not bringing diverse viewpoints into this to help the decision-making that is affecting all citizens in Colorado? I believe that the executive branch needs a checks and balances. It needs to be instituted that rein in the monumental policies impacting everyone from school children to the elderly. And I'll tell you, my mom had a total hip replacement during COVID. For 12 days, I couldn't get her out of the hospital and into a skilled nursing facility because of it, because of random policies being made by the executive branch without any input from others. And then I had to wave to her through a window. And now we see all the evidence coming out about the crisis and the way that we handled it. Children were committing suicide, implications of the way COVID was handled. We have kids that are so far behind. So I'm asking to bring school teachers to the table that are subject matter experts. They're the ones that you closed the schools down on. They're the ones whose kids were in crisis. And they weren't brought to the table. And now we're just going to assemble a group of subject matter experts. Who are those experts? Are they school officials? Are they doctors? Are they naturopaths? Because I'll tell you, the people in my district that took ivermectin were pretty darn healthy. So who are the subject matter experts, and why can't I get answers for those questions? And why does a bill get scheduled the very next day when I can't get answers to those questions? Public officials should be held accountable for policies put in place restricting fundamental rights. We weren't allowed to assemble. We weren't allowed to freely move. We were told to tattletale on our neighbors. We pitted each other against each other. And now we're taking the seat at the table away. And we're saying, here you go, Governor. Here you go, CDPHE. You handled it so very well. We'll take the 19-member group that was giving you some advice away, so only you get to decide what all of our districts go through. Is there going to be someone from rural Colorado at that table? In that subject matter expert? This is poor policy making. Because we hear from our other side of the aisle, you didn't stakehold enough. You didn't bring people to the table. Who are you bringing to the table other than CDPHE and the people in favor of this bill? Because there's a lot of people not in favor. A bunch of people testified against this bill. In the public health emergency, people weren't even allowed to testify. They weren't even allowed to provide public comment. They didn't pull them up on to testify. They took away our freedom of speech because they didn't want to hear it. And constituents are still angry, and now you're going to put the will of the people, you're going to take it away from legislators to talk about it, and you're going to give it to CDPHE, who won't even bring the people of Colorado to the table. That is not the way we do business. We don't take it from the legislative branch. We don't allow the legislative branch or the executive branch to dictate what happens in this building. There are 3 branches of government. Legislators should have a seat at this table because we represent the people in our districts that are calling us and letting us know what's happening. So I'd be a big, big no on this bill. We had time to talk about it. Amendments weren't even, I feel like, looked at. I feel like we could have all sat down. I didn't offer these in committee because I thought I was going to get a seat at the table. And again, buckle up because we're going to read a lot of bills at length. Thank you.
Representative Bradfield.
Thank you, Mr. Chair. I was a no in committee, and in light of all of the amendments that were brought forward today, they were discussed so very quickly and we had no chance to read them. I probably am still a no because I feel like this did some serious alterations on the bill, and I always am somewhat wary of amendments that come up here. Maybe they should go back to seconds, back to the committee and make those amendments part of the bill, and then we could really have something to vote on. Thank you.
Representative Taggart.
Thank you, Mr. Chair. I'd just like to follow up on what my colleague talked about here in terms of local influence. I'm not sure many of you would remember this, but during the pandemic, my county came up through our public health department with a program called the 5-Star Program. That 5-Star Program enabled my local restaurants and retailers to remain open and active, provided they did these 5 distinct criteria in place. That came from Mesa County. That was adopted by the governor, who later said to the public it was his idea. It was not his idea. It was developed by Jeff Coor, a friend of mine, who was the head of the public health department of Mesa County at the time. I, too, think a great deal about this bill. But not having people at the table that have expertise at a local level is wrong. I cannot support this unless we get local people, because we wouldn't have had a state 5-star program, and we would have lost a lot more restaurants and retailers without that program. That came from Mesa County, by the way.
Representative DeGraff.
Thank you, Mr. Chair. I'll reiterate, any fool can make a mistake, but a catastrophe requires experts. And the most deadly part of our last pandemic was definitely the experts and centralized control. We need to have local control. We need to have individual control. having a one-size-fits-all approach that is implemented from probably the most disconnected location in the state, which is Denver, having bureaucrats from the agencies make these decisions is the wrong approach. And yes, I'm a little bitter about that pandemic because they killed my father-in-law. Several times tried to. One time, what saved his life was a charged cell phone because he could call my wife and say, I need water, they won't refill my water bottle. An 83-year-old man in the hospital, they wouldn't give him water. Now, he was deaf as a post, but he could hear the nurses outside of his room. And he could not get water. And so he called us, and we said, well, that can't possibly be true. They weren't treating him. They weren't giving him anything. They were waiting for him to die. Then when he did start to recover, they locked him away and would not allow him to have any contact with anybody except for one person per day for 45 minutes per day. You want to set depression in with somebody? Put them in solitary confinement or near solitary confinement. The experts. That was done by the experts. People need to benefit and suffer from their own choices. The chance that this body has any idea on how to handle anything is very low. The repetition of absurd doesn't make it true. So one thing I wanted to look at, and it's unfortunate that I can't use, and then my colleague mentioned syphilis, and syphilis could also be solved by social distancing. That would definitely be solved by social distancing. But that's a crisis. That's an ongoing pandemic. Our idea for that is just to throw money at it. But for something with relatively low-grade symptoms, then we shut down the entire economy. We spent trillions. We put 30% more in currency, caused 22% inflation, gave everybody a $750 check, all over a study that was about 2.5 months long. So everybody who says safe and effective and we need to trust these things and we need to trust the experts, that study was 2.5 months long. And that would be great if it worked, but you could go to Our World in Data and you can look up excess mortality. Excess mortality, I looked this up this morning, cumulative deaths from all causes compared to projection based on various years. And you know what's really funny is after January of 2020, the rates just keep going up. The rates just keep going up. So excess death, and that's from all causes. And you're like, well, that's really weird. Let's look at the COVID vaccine. Oh, wow, the COVID vaccine pretty much parallels the excess deaths. Now, that would be called a correlation, not necessarily a causation, but when you have something that has such a high correlation that looks so similar, it's probably worth studying. So one thing I did with that, because our experts know better than we do, our experts know better than we, the people, is I went to the trials for COVID, some COVID medications or mRNA gene therapies. And you can do that. It's clinicaltrials.gov, study NCT 04368728 tab equals results. And then you go down and you go to the page that says results submitted. Oh, let's see. The study, recruitment status is completed. That's good to know. The study, the primary completion date was 2023. So has anybody read this study that says it's safe and effective? Probably not, because the results have been submitted, and for the last 2 years, they've been under quality control. So for everybody who's saying safe and effective, you're basing that on a study that has not been released because it's still being reviewed for quality control for the last 2 years. But we need to trust the experts. So I looked at a different study, which was NCT 04516746. Quality control has not been concluded. So we're looking at imposing all kinds of stuff on families, and we're telling them that your kids cannot go to school. We are going to require you to have these vaccines, and maybe they're good, I don't know. I mean, seems like a great idea when you go back to the cowpox and the smallpox and the inoculation, a little different than vaccination. And so I wanted, but you have to have some data actually to make the determination that something is cost benefit. And so you have to know what the risks are, and you have to know the rewards are. So I started looking at some of the risks, and you know what we know about the risks? We don't know about the risks. Do we want to know about the rewards? We also don't know about the rewards because most of these have never been tried against a placebo. Diphtheria. The fourth trial group may have received no vaccines. However, its safety is not presented in the package. The control group in the trial received a different vaccine. The control groups received other vaccines. The only blinded control group had 2 other control groups receiving Hib among other vaccines. So what we're telling the people of Colorado is that you must submit to the government. You cannot make your own health decisions. We have a health crisis that continues to get worse, and we continue to prop up the experts because they're the government, and they're here to help. Most of the control group subjects received DPT or OPV vaccines along with a placebo whose ingredients were not specified. We have no idea what the risks are. We have no idea what the benefits are. We just know what the advertising tells us. The package does not mention any control tests that were performed. Tested against another group receiving a Prevnar, an older generation vaccine. Tested against a control group that received an experimental meningococcal vaccine. Hepatitis B, its side effect rate was compared to that of previous generation, but we don't know what that was. Diphtheria, the control groups received either Infantex vaccine with hepatitis B, Hib, or polio vaccines. So ultimately, a lot of these things are still experimental. We don't know what the benefit is. We don't know what the risks are. So what we have is a multivariate, indeterminate problem with the drumbeat mantra of safe and effective, and this bill wants to tell parents that you must submit to the government, not to any of your own research, not to any of your, and this is not off the internet, by the way. So this bill is a gross overreach. The COVID response destroyed our economy, destroyed children's lives, destroyed the lives of elderly for a bunch of control freaks. And I don't know their motives. When you say subject matter experts, we're going to put this in the hands of subject matter experts and we're not going to identify the subject matter experts. We're just going to give a blank check to the same fools that made the same problems, destroyed our economy, destroyed our families, destroyed our children. And then put a safety clause on it so nobody can challenge it. This bill is a bad idea. Now, for those who worship government, it's a great idea. But if you value the lives of your citizens, if you value the lives of your constituents, if you value the ability of citizens to make choices for themselves, if you have any concern about the consent of the governed, which is to what you took the oath, then you vote no on this bill. It's easy. It's a bad idea. It's a bad idea because it worships government, says government, somehow when people, it does not trust the people of Colorado, but somehow when the people of Colorado become elevated to government, all of a sudden those people are elevated to a status where they can start controlling the lives of other people. If we are a body of citizens, we have just as much information as those citizens do. And we should not be imposing the will of a bunch of people that do not know, that are not experts, and the experts, there's no qualifications in here. What we are signing up the people of Colorado for is just more government control because somebody feels like they care more. They care more than everybody else, so therefore it's their prerogative to impose, impose, impose. Caring more than others, or feeling like caring more than others, Karens. So I advise a no vote on this bill. It's a bad bill. It's good intentions, and it paves the road all the way to hell.
Seeing no further, Representative Luck.
Thank you, Mr. Chair. In 2021, I entered this building as a legislator, and one of the first bills that I put forward was actually as relates to what happens when there is a declared emergency and who has authority when. At the time, I represented 3 counties. Now I represent 5. And each one of those counties has had a very different experience during the COVID season. This bill, because of its title and because of its content concerning modifications to statutes governing disease control, opens the door for me to resurrect that particular bill and policy and the conversation around it. We are now 5 years since that, and we've learned a lot about what took place, what shouldn't have taken place, what should have taken place, and I think that it is time that that particular set of lessons be introduced into our statutes. And so with that, I move Amendment L007 and ask that it be properly displayed.
Members, this is a multi-page amendment, and it was distributed yesterday. It is properly displayed. Representative Luck to the amendment.
Thank you, Mr. Chair. What does this do? Under current law, the governor has the ability to declare an emergency, a state of emergency, and after 30 days, he has the ability to renew that state of emergency. And we saw under COVID that renewal take place time after time after time. Now, it makes sense for one person, when an emergency breaks out, to have that ability to determine what the policy should be for the state. Situations are fluid, information is scarce or confused, resources need to be able to be quickly garnered in order to respond, and having one person, as opposed to a committee of people, engaging in those deliberations and decisions is really the best way forward, having the executive execute in those times of crisis. But after those initial 30 days, when things settle and it's no longer, oh my goodness, what's happening? And people have had an opportunity to think and process and see on the ground what is going on in their particular jurisdiction, and that may be different than what's going on in another jurisdiction. At that point, what this amendment would do is say that the governor does not have sole authority any longer. He still has authority. He can still make determinations that are statewide determinations, but he shares his jurisdictional authority with the local authorities. He shares it with the county authorities, with the city authorities, and due to an amendment I'm going to make to the amendment as a result of feedback from my colleague from Mesa County, the school districts as well, but we'll get to that in a moment. But what that then allows for is people like in Custer County, one of the counties I represent, where there are about 4,500 people, to make different decisions than what is being made in Denver, where there are hundreds of thousands of people. Certain counties shut down, certain cities shut down without actually having to shut down, because the situation on the ground there was not what it was in other parts of the state. And so what this amendment does is it honors other leaders in our state who are closer to the people, closer to the situation, and enables them to make decisions that are best for their particular locale. Now, one might say, wait, they shouldn't have this ability because the governor needs to be able to make these blanket statements. COVID taught us differently. COVID taught us that one size doesn't fit all. COVID taught us that when you have one size being imposed upon people, you have more detrimental consequences in places that didn't need to suffer consequences at all. And so this just allows for that concurrent jurisdiction such that those local voices are empowered to say, yeah, we agree with 90% of what you're doing, but this 10% doesn't apply to us. We agree with 50%, but this 50% doesn't apply to us. Or we're just going to introduce our own set of rules in this particular city because it's a city of 300 people and what's going on here does not actually align in any way, shape, or form with what's being mandated from Denver. Now, as I mentioned, there was a conversation that I had briefly this morning with my colleague from Mesa County, and so as a result of that conversation, I move Amendment L016 to amend the L007 that is currently being displayed. Is that a proper motion?
That is properly displayed. Representative Luck to the amendment.
Thank you, Mr. Chair. Now, what this amendment does is add school districts to the list of jurisdictions that have the ability to make decisions for their body politic, for their people. Why is that important? Well, because a number of us have districts, school districts, that either cross municipal county lines or county lines. They're not strictly geographically in one jurisdiction, such that if a city says we're going to adopt X, Y, and Z, and the county says we're going to adopt 1, 2, and 3, the school district says, what do we adopt? Where do we get put in this? Now, some of you may say, well, that's a reason not to vote for the underlying amendment. My argument would be that's actually more of a reason to vote for this amendment and the underlying amendment because each situation is so markedly different. What's going on in the county of El Paso may be very different than what's going on in downtown Colorado Springs. And so all of this amendment to the amendment does is say that school districts, they have the ability to also make determinations as to what is best for their population and not be reliant upon the counties and the cities and the potential differences between them. And so I ask for an aye vote on both of these amendments, and I thank you for your time.
Representative DeGraff.
Thank you, Mr. Chair. I support the amending the amendment or something. I think it's good policy. I mean, it's always incumbent on us to make bad policy less bad, and I think this is a good effort because we need to have local control. One person making a determination, maybe for a short period of time. I mean, you would have the president that can, commit us to war, and then it has to be backed up by the people through Congress. You don't just get to continually renew your emergency authority. When you give a government agency the ability to continually renew its emergency authority, you get a never-ending emergency. An emergency is just everything the nanny state wants. The ability to control people's lives under the guise of caring more than everybody does. The justification to tell everybody that the government knows better than they do. We had the park next door to my house, we had police tape. We had police tape around playground equipment when kids should have been outside in the ultraviolet light. The experts chased them inside and told them to watch television. There was nothing handled well about that pandemic, and yet we want to codify our lessons learned? Because the nanny state knows better? We need to get the control down at the local level, because I guarantee some of the localities would have handled it much better, because they couldn't handle it worse. And the encouragement from the governor to wear a damn mask. Even though the science had told us previously that they were worthless. Yet we lock down society. There's much more common sense in Colorado than you'll find in the bureaucracy of Denver. And your local governments can make that determination because they are also accountable to the people of Colorado. They are more directly accountable. They are the neighbors. They suffer with. I'm astounded by the callousness of this body to impose its expertise or its lack of expertise on people just because they feel they care more, somehow elevating them. So I'm in favor of these amendments, returning some semblance of sanity and control to the people of Colorado. Because I guarantee if Denver is in charge of another pandemic, well, we'll just have more pandemics. But if Denver is in charge, it will be screwed up all over again. There's nothing that was handled well about the pandemic, except when the pandemic was pretty much ordered by a judge in Florida who said, no, you can't impose masks. And then suddenly it was over. So we need to get control back to the hands of the people. We need to stop thinking that this body has some sort of benevolent dictator ability that we can make everything right. Stop trying to control the people of Colorado. Just stop.
Representative Brown.
Thank you, Mr. Chair. I appreciate my colleagues bringing this amendment and bringing this discussion. This issue was litigated heavily during the COVID pandemic. This would allow any county during an epidemic to nullify a governor's executive order, an executive order that is meant to control disease and keep us safe. Diseases do not know where our county boundaries are, and it would be extremely dangerous if Douglas County or Arapahoe County or Boulder County decided to have different rules that put other counties in their vicinity at risk. I ask for a no vote on this amendment.
Representative Richardson.
Thank you, Mr. Chair. It's an honor to serve the people of Colorado. I'm in support of both of these amendments. As a former county commissioner for 8 years, I never thought that a pandemic would be kind of the formative event of my first term. My good colleague from Mesa County mentioned the 5-star program. We jumped on that. Our public health folks, myself as the chair of our local board of health, and representatives of our restaurant community put together a very common sense plan that allowed our restaurants to remain open a bit more freely than those around us. At the end of this pandemic, of our 26 restaurants, small county, we only lost one during that pandemic, and that was because we had some flexibility. During an epidemic, prolonged state-mandated orders, especially those that last more than 30 days, have a significant consequence on local economies, schools, businesses, and mental health. The previous speaker talked about litigation. Well, litigation happens when there's laws that don't support what you want to do, or there's some conflict in decision-making there. This amendment would prevent such litigation and give proper authority to make local decisions. While state-level coordination can provide valuable resources and guidelines, local decision-making is essential for tailoring responses to the specific needs of the community. Take Elbert County, for example. The population density in my county is 14 people per square mile. The district I represent is 8 people per square mile. We live socially distant. We didn't need the state to tell us what to do. Applying the same restrictions there as in densely populated urban areas is neither practical or necessary. Shutting down businesses, schools, and public spaces for extended period can do and did do more harm than good in our rural areas. They disrupted lives without significantly improving public health outcomes. Local leaders are best positioned to assess the severity of an outbreak in their area and adjust their policies accordingly. We can do it rapidly based on what we're seeing outside our windows, not what's reported up the chain a week or two later. A rural community like Elbert with low case numbers should not have been subjected to the same restrictions as a city where people live in close quarters and interact daily in high-traffic public spaces. Blanket policies often create unnecessary hardship, restricting businesses, schools, and healthcare access beyond what's necessary for public safety. Moreover, and this is absolutely true, prolonged state mandates erode public trust, and they lead to resistance and noncompliance. As I talked to my colleagues out further in the plains, the reaction to a lot of these public orders was, meh, what are they going to do about it? When we had Zoom calls with CDPHE and asked, what sense does it make to shut down restaurants in Phillips County when people can just drive 20 minutes over to Kansas and go to a restaurant? The answer we got was, we don't control Kansas. A lot of this was about control, not about common sense solutions to what's going on. We've got to give our locals control of local situations. I urge a yes vote on these amendments. Thank you.
Representative Hartsook.
Good afternoon, Mr. Chair, and thank you. I rise in support of this amendment, and I would like to share an analogy with everybody that I think you might find interesting, and some of our colleagues might be able to apply to this situation. Now, many years ago, during my service, you're not paying attention. One of the jobs I had when I worked at the Pentagon is we served on the pandemic response. We drafted a plan, I saw that. We drafted a plan of how the federal government would respond. Its response was tailored to support states. It was not to come down and tell states how to do their job. It wasn't to come down and take over the states. It was to provide support to the states. And then if you're wondering why, because we have 50 states in the union and they do things differently. Colorado has 64 counties and we do things differently. If the federal government wants to support states in how they do things, it only makes sense that the states should be supporting the counties and local governments on how to do things versus telling them how to do things or trying to order them how to do things. As my great colleague from Elbert County just talked about, if you drive out to where he represents versus here, you will see more cattle than you will see people. How they do things out there is vastly different than how they do things in here. This amendment is giving that opportunity, saying, let the local counties, let the local municipalities figure out how best to respond, and you, the state, why don't you think about providing us support instead of coming down with a sledgehammer and trying to tell us how to do our jobs? But no, the state of Colorado deems it not only necessary, but incumbent upon themselves. It says, oh, I know best. I, the state, know best to tell counties and municipalities how to do their jobs, to react, to serve their people. Since when is that how we started doing business? If you work for an employer and you happen to be a welder, do you want the general contractor telling you how to weld a seam? I don't think so. The welder knows how to do that. The general contractor is going to say, this is how I want it built. This is what we need to meet. We need to have this deadline done. The welder figures out how to get it done. There's analogy after analogy that supports this amendment and the logic that is behind it, that a state should support what local municipalities and counties want to do. It has been mentioned that diseases know no boundaries. That would be correct. Having been stationed overseas multiple times, diseases don't care where they go. But the people do care. And I will tell you for a fact, having been in many of these places, that we have diseases that we cannot even name yet. Each little local, we won't call it municipality, but local entity does things differently. And if you're wondering why, first of all, because it's theirs and they get to do it that way, that's what they think. But number two, because it best suits their needs. Yet we want to see inside this dome that we know best how to meet the needs of the western slope, the eastern plains, the southern part of the state, the northern areas. And we know what's best for all the surrounding county and municipalities. I know there's 64 counties, a few hundred municipalities in the state. We have one state government. Federal government shouldn't be telling states how to do their job. The state should not be telling counties and municipalities how to do their job or how to protect their people. Leave that up to the local authorities that are sitting there. In my county, we finally got fed up with CDPHE and we withdrew from Tri-County Health. We started our own health organization. We opened up business. It helped businesses. It helped consumers. It helped families. We had everybody shopping down in our county. Our tax revenue went through the roof. Life was good for us. And we did a really good job about it. That's what this amendment is about. That's what this body should be doing versus trying to exert its will and control over the people around this state. I urge an aye vote. Thank you.
Representative Bottoms.
Thank you, Mr. Chair. So local control, I believe that very strongly. It was said earlier that diseases have no boundaries. That's why when all the other states opened up 3 months, 4 months, 6 months into this and their economies took off and we kept our economy closed, we lost 40% of all of our businesses. So that proves that diseases have no boundaries because this was not a real thing. And the distancing and the masking was a joke. Now here's the thing with this both of these amendments. Let me build a scenario for you. Let's just say that we know that we're going to have a new governor, right? And this is going to apply to the new governor, all right? We don't know who that governor is going to be, but let's say that that governor was somebody like me. Does everybody in this room want me making all these decisions? I'm not looking at my side. Do you really want me making all these decisions and putting these groups together and deciding who's going to be on these panels? Because you never know. We don't need the governor to have this kind of control. It's not healthy it doesn't matter who the governor is. It doesn't matter which party they're in. We don't need the governor to have this kind of control. And so as you vote for these amendments, just see my face in your head.
Representative Taggart.
Thank you, Mr. Chair. I don't know how to follow that up. So, on these amendments, the first one, just as a reminder, our request for local control only kicks in 30 days after the emergency. It's not right at the very beginning of the emergency where we probably do need that single individual to put the emergency plan into place. But I wanted to speak about this second amendment because my colleague called me out, and I appreciate that. One of the reasons I asked her to add school districts is the fact that we have school districts that go across many municipal boundaries, and in some cases, county boundaries. And I would want those different governmental institutions to collaborate with one another, but it would make things very difficult for a school board, for instance, in my district, which is District 51, if the city of Grand Junction said that they were going to take a certain, put certain ordinances in, and the city of Fruita did something totally different. That puts school districts in an almost impossible situation. So again, I would always want them to collaborate, but because school districts don't align with municipalities or county boundaries, that's why I asked for this to be added to the amendment, and I thank my colleague for that.
Representative Garcia Sander.
Thank you, Mr. Chair. I just need to go to bat again for our rural counties and our rural schools. When the COVID pandemic hit, there were blanket regulations that hit our state, and those blanket regulations and rules didn't work for everybody. And, you know, we're all individuals. We all have individual districts that we represent. It is so important that we recognize that there are rural counties and rural municipalities that the COVID regulations did not work well for. They didn't need to be that heavy-handed. And this goes for so many of the things that we see come out of the legislature that are so Denver Front Range centric. We need to remember that we are representing not just our 88,000 people, but the entire state, and that's all four corners. Those are the rural areas, those are the eastern plains, the mountain areas, yes, the central front range, but there are a whole lot of other people that we should be considering also. So I encourage an aye vote on this amendment. And the second amendment.
Representative Sukla.
Well, they saved the second best for last. I was a Montezuma County Commissioner during COVID, and the first thing that happened was our health director, which the Board of Commissioners are also the Board of Health. And our health director came and said, we would like to hire 5 enforcers. I was the chair at that time, and I said, well, what is an enforcer? And they said, well, an enforcer is, we've got some small businesses in Montezuma County, and we want to go and fine each one of those employees in those small businesses $1,000 per employee. So I looked at the health director and I said, well, the first thing, we're not going to hire the 5 enforcers, but what we're going to do is you go ahead and you fine those small businesses, each employee that is not wearing a mask, $1,000. You go ahead and do it. And then we're going to do is the county, Montezuma County, is going to pay the $1,000 fine. If that's 100 employees, that's $100,000. If that's 200 employees, that's $200,000. And then what we're going to do is when you do your budget in October, whatever that number is, we are going to lower your health department budget by that. Guess how many businesses, after we put the pain that they were going to put on the small businesses back on the health department, how many that they fined? 0. I'll tell you the other thing, we live so far from here that they think that we are Montezuma County, New Mexico. They don't even know where we're from. So 3 weeks into it, the churches started coming and they said, we would like to go ahead and have Mass. We're just like, but the governor said that we can't. And we said, when's the last time you seen the governor here? They think we're from New Mexico. Go ahead and do it. And they did. Then they started telling you, if you get us, we'll give you a 6-pack of beer if you will take the shot. We will give you a dozen of Krispy Kreme donuts if you'll take the shot. But you cannot go to the gym. This here is about local control. And the only time I wore a mask was 4 times. The first 2 was at the dentist's office, and this is what they told me to do. You got to have that mask on, and then you walk through there, and after you sit in the chair, now they take the mask off and they stick your hand down your throat. And the other 2 times that I wore the mask is when I got a little skin problem. If you can't tell, I'm kind of light-skinned, and I had to do that stuff they put on your face. It's called blue light. And then they made me wear the mask, call them so they could take me in. They put me in there, and then they said, take the mask off, and they stuck their hands all over my face, putting that acid stuff on there. I'm sorry. It was ridiculous. We need to go to local control. This bill, I suggest that we vote yes. Thank you.
Representative DeGraff.
Thank you, Mr. Chair. I also support the First and Second Amendment, and I think you should too. But we're talking about these amendments, which I also think you should support. It was great to hear some laughs. Unfortunately, this bill is a joke, but it's not funny. Nullify, when we talk about the worship of government, the church of woke, the church of government, these amendments, everybody prepare to gasp, would allow counties and citizens to nullify, wait for it, an executive order. Thank you. It shocked me too. Nullify an executive order. You would deign to nullify an order from the executive. Now, I don't know if anybody knows what an executive order is, but an executive order is an order from the executive. To whom? It's an order from the executive to the executive agencies as to how that executive wants his agencies to respond, to behave, to act, what their processes should be. That's what an executive order is. An executive order to you? That's an interesting piece of paper. But what we did is we allowed our local officials, because there was money involved, to start using the force of law, which ironically you want to defund and reduce, while piling on law after law after law to restrict and restrict and restrict. But those only apply to law-abiding citizens, so the only thing that you really care about is restricting law-abiding citizens. There's no social distancing required for the syphilis epidemic, just for a minor cold. Nullifying an executive order. Let's think about where the executive falls in terms of our Constitution, our federal Constitution and our state Constitution, which cannot be in violation of the state Constitution. I mean, contrary to what's done in this room, which is assumed to be constitutional, especially when you put on safety clauses so the people don't have an opportunity to petition, which would be against the First Amendment, which is one of the first ones I supported. So, who is sovereign in our state? Individuals are sovereign in our state. What is the purpose of government? That to secure these rights. among which are life, liberty, and the pursuit of happiness. The purpose of government is to secure the rights of the people. The job of the legislature is to pass laws, to make those laws that secure the rights. Not to govern away the rights of the people because we care more, you care more, I care. I just want people to be able to make their own decisions because I actually trust the people of Colorado. But elections have consequences, and right now we have a majority that does not trust the people of Colorado to govern their own lives. And so the nannies of the nanny state are going to continue to impose their will because they care more, even if it kills you. And the pandemic is a great excuse, is a great example of how often the nanny state will impose its will, even if it kills you, because it does. So the people in the state are sovereign. The purpose of government is to secure the rights. The purpose of the legislature is to pass laws, the bare minimum that are needed in accordance with the Constitution, which is the executive document of the Declaration of Independence. So the people are sovereign over government, and that's why you took an oath to support the rights of the people. You took an oath to secure the rights of the people, not show them how much more you care than they do. That's why it's called the nanny state. So where is the executive in this? Well, we have the people, top layer. They're the ones for whom the Constitution is written. The Constitution is written to protect them from you. So you should be writing laws that protect them from you. And then the governor is supposed to go out and execute those laws that protect the people from you. So the executive is way the heck down there on the list, well below everybody. It's really kind of the lowest office in the land because it is supposed to support and execute the will of the legislators who are elected by the people to secure their rights.
Representative DeGraff, if you could bring us back to the amendment.
Yeah. I'm trying to remind people why we need these amendments, because this bill is in complete violation of our entire form of government. Under the guise of we care more. And caring more is always an excuse to control more. This is a control bill. So the executive, nullifying the orders of an executive, you really don't have to nullify the orders of an executive because they don't apply to you, citizens of Colorado. The citizens of Colorado are superior to the governor of Colorado. We get this idea, we have this monarchist mentality that seems to be in our DNA that somehow the governor is the highest office in the land instead of the lowest. And we just heard it here. How dare we deign to nullify the orders of the executive? Because the executive, just like this body, is somehow imbued at election with the ability to know all, do all, see all. And he knows better than you. This worship of the executive, the worship of the governor, the worship of government is really disturbing in this room. The majority complains about the governor and calls him King Polis because of his lack of regard for the other branches of government. And then we create a bill because, goodness, the citizens of Colorado might, or the local governments of Colorado that are closer to the citizens of Colorado, because why do we have government? We have the government because citizens have banded together to create a government to represent their rights collectively, to defend and secure their rights collectively, not take them away, not care more for them. You took an oath to it. You should know what it means. The people are sovereign. The government is there to secure the rights. The governor did not become a virologist, a bacteriologist. He didn't become any of those things. An economist, certainly not an economist. And what we come down to is if a good intention was a good idea, it wouldn't require a gun. If this bill was a good idea, it wouldn't need the force of law behind it. It wouldn't need law enforcement behind it because it would represent the best interest of the people instead of the pearl clutching of the nanny state. We need to get the nanny state out of people's lives. They don't want it there, and they certainly don't want to pay endlessly for it. Nullifying an executive order. Absolutely, you should be nullifying the executive order. It's a travesty that we had anybody enforcing executive orders, acting like they were some force on the citizens of Colorado. Yeah, local governments did that, primarily for money. Money, access, gratuity. It's disgusting because local government should be the primary line of defense against this body, which cannot seem to keep its hands off the citizens. So, that's of course why you don't want anybody to be able to appeal these bills. So it's another example of the nanny state, over-nannying, trying to overprotect, but really, it's all about control. This is the jackboot of good intentions.
Representative Kelty.
So someone asks part of the reason why I ran for office. This is kind of it right here. When I think I don't need to, I get up every morning thinking, am I going to have to shake my head today? And man, am I shaking my head today. Oh my goodness. So problems should not be painted with one big brush. You should want your local areas to have the control over your local areas. The fact that you trust the entire state to make all your decisions for your local areas, wherever they may be, is kind of troubling to me. You know, during the pandemic, we saw a lot of mistakes made. Even our leadership admitted to lots of mistakes made. Who are we if we can't learn from those mistakes? And why can't this body learn from these mistakes? It seems like we keep making them over and over and over. You know, when our leadership admits to mistakes, how about we take that for action and try not to make them ourselves? We need to have smarter legislation and actually learn and put forth things that are actually going to help everyone in their own individual areas and their own individual ways. And painting it with one big brush is not it. I'm asking you to please vote yes on the amendment. It makes sense. It's common sense. You should want that for your people. Stop giving all the power to one body, to one person. Stop taking the rights away from your people. They're not your rights to take. It's your rights, it's their rights to defend. You should be acknowledging them all. And by saying no to this, you're showing your people you don't care about their rights, you don't care about their voices, and you don't care about them. That's my opinion. Thank you.
I will remind members to not impugn the motives of their colleagues. Representative Wu.
Thank you, Mr. Chair. I do support this amendment. I did hear from my colleague from Louisville that, and I'm paraphrasing, that it's dangerous for counties and municipalities, school districts, to be able to make these decisions, to be able to have these options. And that, frankly, is offensive. It's offensive to me as a former trustee in Erie, Colorado. I'm sure that many local council members and mayors and county commissioners would feel the same as I do. How does the governor know what's best for their communities? This is simply, after 30 days, an option that communities who know what's best, for their residents get to make these decisions. This is good for the residents of Colorado. It's a common sense amendment. This is just simply common sense, allowing municipalities, counties, school districts to have options. I urge a yes vote. This is a very great amendment.
Representative Bradley.
Thank you, Mr. Chair. I also rise in support of this bill, and one of the things that I talked to the bill sponsors about, both amendments, I'm sorry. I feel like, are we still on the same bill? Am I still on 1027?
Just so folks remember, we're on an amendment to an amendment.
I'm in support of the amendment to the amendments. We have 64 counties in our state. We should give them the ability to decide what's best for their counties. Douglas County, for instance, I think the best county in the state of Colorado, decided that Tri-County was not doing their job, and we got rid of them, and we formed our own health board. And it has been the best thing that happened to my county. That's what we do in this building. We stand for local control. Unemployment rates during COVID skyrocketed. In fact, I looked it up. At the end of 2020, there were 269,000 people looking for jobs at the end of COVID. Suicide skyrocketed to the point where Children's Hospital, located in Douglas County, declared a state of emergency. You're taking the ability for local districts to solve problems that are important to them and strictly associated with them. The economy tanked, 38% of small businesses closed, but we grew government by 6,000 employees in this state. So remember that. They closed down the businesses, but they grew government by 6,000 employees. I just want you guys to remember that. Healthcare workers left our state in droves. I'm a healthcare worker. They said, vaccinate or you lose your job, and guess what? They left. And guess what we're paying the price for? Maternal deserts everywhere, rural health deserts everywhere. We can't get dentists in rural Colorado. We can't get ophthalmologists and optometrists in rural Colorado. We can't get nurses in rural Colorado because we made them leave. We told them an experimental vaccine was more important than us having you work here. Firefighters left in droves. Police officers left in droves. Pilots left in droves. We mandated for these healthcare professionals and other professionals what to do instead of letting the districts take charge of that. And now, because of what the state has done during this emergency, rural Colorado and the people of rural Colorado, which I represent in Douglas County, are left to pay the price. So why wouldn't we accept an amendment that brings everyone to the table and lets them decide? Children weren't even dying from COVID, and we shut down the schools. You know what they were dying from? Suicide from shutting down their schools. They died because you socially isolated them, because the state decided to do that, and we went into a crisis. How dare you not learn from that? How dare you say we care for kids and not learn from that? How dare you take local control with this amendment away from our districts that we all represent? There are consequences to our actions. They don't deserve to have all the control when it comes to an emergency. The districts should be able to come to the table. And I've read every masking report out there because I'm a healthcare worker and I was scared of COVID. I didn't want to die. I have 4 kids. Every random control trial shows that masking doesn't work. You can put 5 on if you want, but it's not going to work. The molecules are too small. They permeate through the mask and they infect all of us. But that's who is in control. Wear 5 masks. Socially isolate. Wear one in your car, for goodness sake. Don't keep usurping the control of our districts. We were all put here by our districts. We weren't put here by the governor. Our districts elected us to come up here and fight for them. The state of Colorado didn't put us up here. Douglas County put me in here to fight for my district. They didn't say, please go fight for the state of Colorado. They said, fight for what we need in our county. So why do each of us keep usurping that role? It's not good governance, and I believe during third reading, one of you actually came up here and talked about the importance of local control. So local control cannot just be important when it fits your narrative. Local control should always be important. I suggest an aye vote on this very important amendment to tell the people of Colorado we respect our districts that voted us in, and we will respect their decisions on how they want to go through a state of emergency. Thank you.
AML Winter.
Thank you, Mr. Chair. Being from rural Colorado, I'd like to speak to this. I spoke about parental rights the other day and the ability to make your own decisions for your family, and it's no different here. I said this last year, and I said this on the campaign trail. Sometimes it doesn't feel like we live in two different parts of the state. Sometimes it feels like we live in two different states. And that's how my constituents feel. And when you make decisions for them, it's kind of insulting. It's like we're not smart enough to figure it out for ourselves. And that's just not right. Rural Colorado voices matter. Big city fixes exasperate rural problems. It's cause and effect. So when they shut everybody down, I put my kids on a school bus, and they drove about 50 miles each way, up in the morning at 5:15 in the morning, not home after sports until sometimes 8, 9 o'clock at night. And they went on field trips to Oklahoma to do FFA, and they went to Kansas, the states that didn't lock down like this. And my kids are alive still. Didn't lose anybody from that school, teachers. Because we looked at the data, we looked at the news, and we wanted to make a decision for ourselves. And there were a couple school districts that thumbed their nose at the state and said, it's more important that our kids are with each other, that our kids are learning, they're socializing. In rural Colorado, if you don't know, you should know that we have a higher rate of suicide than our urban cousins. So that would have exasperated that problem. Don't get me wrong, some of the kids in our district, they play it, but our kids do 4-H. Sports are the center of our communities. That's our gathering place. Church is our gathering place. There was a bill yesterday talking about separating people. It's not the same thing, but kind of the same thing. And it was hard to watch that. But I would urge you to look at the testing scores of the rural schools in southeastern Colorado compared to the urban schools during COVID. And I think that data will prove something. And when the mandates started and the lockdown started, rural Colorado stood up for itself, because guess what? Whether you want to believe it or not, that was a test of a free people. And rural Colorado passed that test, and I'm honored to be from rural Colorado. I'm honored to be a free thinker, and I'm honored to know that our rights come from God and not our government. I'm a yes on this amendment. We talk about working across the aisle all the time. You have representatives from rural Colorado saying this is not a one-size-fits-all issue. We are begging you. You know, like I said, it's a shame every year when I leave here in May, I have to go on an apology tour. That's what I do in the summer. I go look at a bunch of people that are looking for help and they feel like their voices aren't heard. And it's always, we hear you, but. Actions speak louder than words. Vote yes.
Is there any further discussion on Amendment L16? Seeing none, the question before, I'm sorry? Division has been called. Committee will go into brief recess. Back to order. The question is the adoption of Amendment L16. A division has been requested. All those in the chamber not entitled to vote, please be seated. Okay. All those in favor of Amendment L16, all those in favor, please stand and remain standing, or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place until the count is taken. You may be seated. L16 is lost. To Amendment L7. Is there any further discussion on Amendment L7? Seeing none. The question before us is the passage of Amendment L7. All those in favor, please say aye. Aye. All those opposed, please say no. No. L7 is lost. To the bill. Representative Bradley.
I don't want to be discriminatory, calling somebody the wrong something. I caught that. Do you need to recognize me?
Representative Bradley.
Thank you, Mr. Chair. I mean, that was close, you guys, so I have a good feeling about mine. I move Amendment L017 to House Bill 1027 and ask for it to be displayed.
That has been properly moved, and Amendment L17 is displayed to the amendment. Representative Bradley.
Thank you so much. This is what I was talking about earlier. I don't love that it says the group of subject matter experts. So I'm just adding a couple people that I'd like to see in there, along with whoever the governor wants to add to. I think it's a very fair amendment. The group of subject matter experts is assembled pursuant to subsection 4AI. This section must include at least one individual who is an allopathic doctor, a naturopathic doctor, an economist. I mean, hey, a small business owner or member of a chamber of commerce in a rural area of the state, a small business owner or a member of a chamber of commerce in an urban area of the state, the director of a county health department in a rural area of the state, the director of a county health department in an urban area of the state, and a school administrator. These are just adding to the group. I think these all will have really good perspectives as to how we handle an emergency in the different parts of the state, from the local business community to the schools. And I think that this will really help negate the horrific effects of social isolation if we have to go through this again. I think teachers need to be brought to the table. I think small business owners throughout our community need to be brought to the table. We can't just make mass decisions for our economy. Our economy tanked, small businesses closed, horrific outcomes because people weren't brought to the table. I think if we open this up and we have more people at the table, then hopefully we can handle the next crisis or emergency better, and we'll be better prepared because we have different people from different perspectives adding significance to the discussion and the conversation. I feel like this is a very fair amendment. I don't know why we wouldn't accept this amendment unless we were just telling the small business community or the business community that we don't want them to have a seat at the table. If we're just telling naturopathic doctors that we don't want them to have a seat at the table. During COVID, there was a lot of natural remedies that could have been used. And we were so focused on the pharmaceutical companies that we negated high vitamin D being brought to the table. We negated zinc being brought to the table. We negated monoclonal antibodies being brought to the table. Ivermectin being brought to the table. If a naturopathic doctor comes to the table, they can provide some good insight as to how we save. I had patients die. They said to our community that patients with heart and lung problems were the people that were dying the most, when in actuality it was diabetic patients. 2 of my diabetic patients died. Nothing was offered to them other than to go into the hospital and get on a ventilator, and we all know the outcome of that. I want other scopes of practice brought to the table. If we can save people in our community through other ideas, then why wouldn't we invite them to the table? We talk about it all the time in this building. Did you stay cold? Did you stay cold? Well, you didn't stay cold enough. Well, you left this person out. Bring a diverse group of people to the table. So in the next emergency, we have inclusive thoughts from other members in our community, not just the people driven by profit. Let's open this up. Let's bring the people that are suffering in our community, because when I talk to people in my town halls and other meetings, I learn a lot, especially from people on the opposite side. I love talking to Democrats in my community. I learn a lot. Widen the net to include others at the table so that they can help out in this response. This is a fair amendment, and I ask for an aye vote.
Representative DeGraff.
Thank you. Thank you, Mr. Chair. This is a good amendment. I mean, it's a good effort to make a horrible bill less bad. Since the bill does not recognize the ability of citizens to make determinations for themselves, despite the horrible response. My colleague mentioned ivermectin. Again, my father-in-law, we took him to the hospital when we thought we had to. They sent him home because he wasn't ready to die. They said, bring him back in a few days. We took him home, we gave him ivermectin. The next day, he was pretty much dead. He was pretty much better. It was eerily better. And he improved daily until the next week when the bacterial pneumonia took over because they hadn't given him any antibiotics. Because the experts had determined that he was suffering from viral pneumonia and didn't give him antibiotics for the pneumonia that he had in his lungs, and it had spread to his lung. It had spread throughout his lungs. But ivermectin, combined with zinc, vitamin D, all that, he was better the next day until the experts killed him. My mom got COVID from her twice-vaxxed caregiver for my dad. We gave her ivermectin, zinc. She was better the next day. It's a Nobel Prize winning drug. It was on the list of CDC, things on how to treat it. But somehow the experts who were profiting from it said it wasn't and said it was banned. It was there on the CDC page. Putting a health issue in the hands of a bunch of, well, one, non-elected, non-representative, people just called subject matter experts with absolutely no definition in light of the complete botched response from last time by subject matter experts. I mean, this bill is just an example of that there is no problem the government can't make worse with a solution. And the worship of the governor now is just beyond the pale. But putting the liability, I mean, that's part of the problem, is you're putting the liability of all of this on the governor and making that a governor's decision. And of course, the decision is going to be to lock everything down. So I support this bill. Not because I think these people should be in charge of our health, but because it's an effort. It's an effort to put some level of accountability into this overreach by the nanny state. So it's a good bill, it's a good amendment. Again, it's not going to save the bill. It doesn't make the bill honoring to the people of Colorado and say that, hey, you know, your legislature is here to protect your rights. I mean, this bill is still a gross overreach, but this helps. This helps ensure that we have some actual people who know what's going on, not whoever was doing the decisions last time, because they clearly did not. Yeah, I'm a little bitter because the experts killed my father-in-law. That makes me a little upset. So with the experts, I just wanted to read something that I captured, screen captured from 2021. While the vaccine is highly effective for 6 months, the virus will continue to have opportunities to mutate, and there's no guarantee that variants capable of dodging the current crop of vaccines won't emerge. And this is a quote that was published by the hospital in my area. Indeed, as increasing numbers of people are fully vaccinated, a viral variant capable of evading vaccine protection, should one emerge, will find fertile ground among the vaccinated majority. Immediately after this was printed, it was promised that everybody who got a vax could go out. And what happened? It created the variants, just like Pfizer said would. And then the lockdowns came after the summer again. So the experts, the subject matter experts, you don't even know who the subject matter experts are, but you put your complete trust in them. You put your complete faith in these people called subject matter experts because somebody calls them a subject matter expert. The love of government over the protection of the citizens. Secure these rights. Governments are instituted among men, deriving their just power from the consent of the governed. From the consent of the governed. From the consent of the governed. So anyways, this is a good opportunity to make a horrible bill less bad. Vote yes.
Representative Brown.
Thank you, Mr. Chair. Briefly, we ask for a no vote on this amendment. This amendment modifies a section of our bill that relates to crisis standards of care, which are standards of care that are used by healthcare providers and healthcare facilities like hospitals in responding to a public health emergency. This isn't really about masking or vaccines or anything else. It's about how do you deal with the incredible surge of patients that you get during a pandemic like COVID-19 or something else. So it really doesn't make much sense to me to have an economist or a small business owner on a committee that's talking about how does a hospital deal with the surge of patients that they are dealing with because of an inordinate public health crisis. I ask for a no vote.
Representative Luck.
Thank you, Mr. Chair. I think that one of the problems with this particular provision in the bill is that it doesn't actually define what that group should be comprised of. So if we go back to the hypothetical that our colleague from El Paso County made about possibly being governor, and then we think about how that person would possibly appoint, I don't know, the representative from Douglas County to be the executive director of CDPHE, and she would have the authority under this to assemble whatever group of experts, because there are no actual provisions, there are no actual definitions of who she could or could not assemble together. The question would be, would you want to empower that representative who's been appointed in our hypothetical as the executive director of CDPHE to make those decisions without any guidance? Perhaps you do disagree with this particular set of members and you'd want to amend it, but the question still remains. Do you want to delegate that authority in full to someone who is not accountable in an elected capacity and who could be appointed by who knows who when this situation, which hopefully God willing will never happen again, happens? So again, regardless of whether you agree this is the particular composition of this group of subject matter experts, it does bear discussing what that group should entail. Most of our bills, when we talk about creating a committee or a group, we outline who they are, how long they'll serve, how they're appointed, etc. The who being the most important aspect of it. Who are these members? Is a group 2, 3, 5, 25? Someone from each county? What kind of group does this body actually want to see created? And I don't think that that is too much to ask to make sure that that particular set of parameters is enshrined in law such that you are not giving this broad authority to whoever is in that position at the time. Thank you.
Representative DeGraff.
Well, it's leading to an interesting conversation, and maybe some of these people shouldn't be on there. And so maybe some people shouldn't be on there, but not defining, the more grievous error here is not defining subject matter experts. And I'm not so sure that some of these people shouldn't be on there, on these standards of care. Because clearly the standards of care that were implemented were much more broad than they should have been, and the harm that was done by the standards of care were broader. So if you don't like this list of standards of subject matter experts that are going to be brought together for this entire thing, at least come up with your own list. An economist is certainly not going to hurt to have around. Have an economist? Man, somebody having some clue about the economy would have been nice in the last pandemic. Small business owner? Somebody with some clue about small business would have been good to have around in the last pandemic. Maybe they just sit quietly until they come up and they go, you know what? Maybe you need to think about this. Maybe you need to have some out-of-the-box thinking. Because the deification of experts in the last pandemic got people killed. So if the sponsor does not like this list an attempted list of experts crossing all of the areas in which a pandemic would impact, that is a failure on the part of the sponsor. You really can't get more broad or more banal than subject matter experts. We're going to put the pandemic in the hands of subject matter experts. We're going to get rid of the GEERK squad, and we're going to give it to subject matter experts. At least the GEERK squad had some sort of structure. Ultimately determined by the governor, or then there's a CDPHE to do this, whose director is also appointed by the governor. So this is just another redirect in terms of putting it in the hands of the executive to appoint subject matter experts. Do we have any idea who the governor thinks are subject matter experts? Have we asked him? Did he give you a list? Certainly he was consulted. Does he have a list of subject matter experts anywhere? Anyone? Anyone? Bueller? Not a single subject matter expert is listed in here. How do we know they're experts on a subject? What are they subject matter experts in? Horticulture? Maybe they're subject matter experts in beekeeping. I don't know. They're not defined. So at least this is an attempt. This is an attempt. You have a pandemic, cross, wide-ranging. This is a wide-ranging group of subject matter experts. At least they're a group of subject matter experts that look like they would have some connection, some foothold on reality, which, by the last pandemic handling, was not a consideration.
Representative Bradley.
Thank you, Mr. Chair. And this is why rushed bills are not good governance. I wanted to sit down at the table with CDPHE and the bill sponsors. I agree. If this is such an egregious list of people, then determine what it is. But I think it goes against everything we believe in just to put in a bill, assemble a group of subject matter experts when we're talking about a state emergency that's going to affect all of our districts. This is a start. Let's build on that or come back to the table. But stop rushing through bills before we have a chance to sit down and talk. I urge an aye vote on this amendment. Thank you.
Seeing no further discussion, members, a division has been called. question before us is the adoption of Amendment L17 to House Bill 1027. A division has been requested. All those in the chamber not entitled to vote, please be seated. All those in favor of Amendment L17, please stand and remain standing, or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand or raise your hand and remain standing in one place until the count is taken. You may be seated. L17 is lost. To the bill. Seeing no further, Representative Bradley.
Just getting started. Thank you, Mr. Chair. Stretch out, Brett Bacon. I move Amendment L012 to House Bill 1027 and ask for it to be displayed.
That is properly displayed. Representative Bradley to the amendment.
I would like to amend printed bill, page 7, line 15, strike wanton or willful misconduct and substitute gross negligence. And let me explain why I want this change and why I tried to work with the bill sponsors and CDPHE. Wanton and willful misconduct implies a conscious disregard for the safety of others, meaning the person knew their actions could harm and deliberately acted despite that knowledge. We know that's really, really hard to prosecute and bring up on charges. I think gross negligence fits better, indicates a severe lack of care, essentially showing extreme indifference to potential harm without necessarily proving intentional wrongdoing. And the reason I'm bringing this forward is because there were several solutions to COVID. There were several different options to COVID. And we ignored all of the natural ones. We ignored ivermectin, vitamin D, zinc. My stepmom, who is immune compromised, needed monoclonal antibodies. She went out of state and found them and was pretty much healed after 2 days. And we had people going against these solutions, actively saying that these things didn't work when they were saving people. There should be ramifications to this, and they should be prosecuted, and they should be able to be prosecuted more easily. I've yet to find anyone who died from taking high-dose vitamin D or ivermectin. I've yet to find anyone that died from monoclonal antibodies. We need to hold people making these decisions accountable so that they will provide all solutions. They can't just provide a small group of solutions, meaning that these aren't just big pharma solutions or meds that put people on ventilators. This is a good solution. This will keep the medical community accountable to bring everything to the table and not just bring something that takes them down a path of financial opportunity. I ask for an aye vote on this amendment.
Representative Brown.
Thank you, Mr. Chair. This particular amendment modifies the standard of essentially of liability for state officials working a response. It no longer would conform with what we have under the Colorado Governmental Immunity Act, and so it would be out of step with the rest of our statutes. So we ask for a no vote.
Representative DeGraff.
Wow, there's nothing, just really nothing, that says experts like being shielded from immunity. So we have a group of experts from the government. I'm the government. I'm here to help. Most terrifying words. They're so confident in their ability to run your life on behalf of the nanny state that they limit their liability and say, you must do exactly what we tell you to do. We'll put you in jail otherwise. And if we're wrong, there's nothing you can do about it. So this is really a good amendment to point back to the gross overreach by the nanny state. The nanny state gets to step in and tell the people of Colorado that we are going to bulldoze your rights, and then we are going to step outside. We're going to sidestep any accountability for our actions, no matter what those actions lead to, like the death of my father-in-law. And the death of many others. Nobody died from too much ivermectin. Nobody died from too much vitamin D, but they did die from the shot. I do know people that suffer from Bell's palsy because of the shot. But you know who's not responsible? The people who made them get it. Subject matter experts get to step in and sidestep the results. It's just fascinating that we're getting more and more reason to not vote for this bill. It will be voted on. I'm sure it will be approved. It's part of the worship of government. It just is. Willful misconduct, willful disregard. One of those things was masks, which, if you look at the emails from Dr. Fauci, he said they were useless. Of course, then he also said you should wear 2. Bunch of studies, have the links, no effect. For those of you who are freaked out about carbon dioxide, who are superstitious about that wonderful molecule, 13,000 ppm that you were subjecting kids to breathe. Do you want to know why they tore the masks off their face? Because every part of their physiology says this is a bad idea, and your subject matter experts are full of not expertise. Yet you strapped your kids down, even though anybody with half a clue knew that the incidence rate of children was minuscule. Subject matter experts get to sidestep their profit motive. There's no studies that showed masks were effective at all. Just the continual mantra of social distancing. Study after study showed they did absolutely no good. Study after study showed that the continual inhalation of fibers and titanium oxide, which is put in there as an antibiotic, as they broke down in the sun because people would leave them on their dash. I mean, we still see people driving around in their cars by themselves with masks. I know how they vote. Telling kids to wear a Petri dish on their face all day long, where they breathe humidity into it. Warm, humid air, full of bacteria. And then breathe in warm, humid air, full of bacteria. Subject matter experts said that was a good idea. Children have lost about 2 years on their academic studies. Our kids are 2 years behind because subject matter experts. So yeah, you should have an educator in there. Because when somebody who just cares more than everybody else says everybody should wear a mask because I think that's a good idea because I don't have a clue about virology or bacteria or fibers or sunlight. But doggone it, they care more, so they should be listened to. 150 studies makes no difference whatsoever. They studied in European countries, they studied them here, where they were wearing them, where they weren't. There's a reason that people didn't want them, because everything about your physiology says this is stupid. And stupid is failing to learn lessons from the past. The best thing that you could do is actually breathe fresh air. Droplets fall to the ground. Exhalation might float around. It doesn't help. What we needed to do is build immunity. But you know what we did instead? We listened to subject matter experts with no accountability whatsoever because they're from the government and they're here to help. It is about the subject matter experts and helping. Their good intentions. This bill is about good intentions. It's not about science. Certainly we're not having a discussion about science. We're having a discussion about the control of the population because somebody thinks it's a good idea because they care more, and you can't trust the citizens of Colorado to take care of themselves. They're just helpless sheep wandering around Colorado waiting for the nanny state to step in and tell them how to live their lives. Because we want subject matter experts. If we're going to have subject matter experts in a pandemic, or we're going to have the governor make the decision in a pandemic and make the decision to continue time after time after time how the medical is going to run, how our economy is run, how our schools are going to run. I was going to ask, why don't we just have him do that all the time? But I guess we're already there. Willful misconduct, willful disregard. This is saying that these subject matter experts that should have taken into consideration something other than their own superstitions should have probably taken something that they should suffer some consequence for their actions. If we don't want the government to be liable for the decisions that it imposes on the citizens of Colorado, here's an idea. Stop having the government impose decisions on the citizens of Colorado. Why does everybody in here think they're better, smarter than the citizens of Colorado? I mean, until a couple of years ago or until a couple of months ago, you were one. But now you don't trust them because you're in the hallowed halls of green. And now you know better. I mean, I don't remember getting imbued with some shot. I mean, fortunately not, but some shot that gave me some. I can wait. This is about willful misconduct, willful disregard. There should be consequences for it. People died. People died from isolation. People died from depression. People died from the masks. People died from the shots. And Colorado, no one cares. It would be good for the people of Colorado to come and sit in the gallery where that has been provided for oversight so they can see how the laws are made in this body, how the deals are mainly cut in back rooms, how the committees rubber stamp, how the green room's rubber stamps, and we mow over your rights by saying the government knows best. The government gets to tell you what to do, and the government has absolutely no accountability when it makes a mistake. I don't know how, just the absolute hypocrisy of that. It is just begging for abuse. And abuse is what happened to the citizens of Colorado. This bill just solidifies it. Solidifies the protection of willful and wanton negligence because it's the government. And nobody cares.
Representative Soper.
Thank you, Madam Chair, and it's an honor to serve with you.
And an honor to serve with you. And it's an honor to serve with you.
Members, I want to come down here and speak in support of the amendment and address a comment made by the bill's sponsor. So the sponsor of the bill indicated that the reason why they couldn't support this amendment was that it fell out of line with the CGIA, or the Colorado Government Immunities Act. However, I will say that it's important to understand what the Colorado Government Immunities Act is and is not. So it's also found within Title 24, as is the section we're amending here, but the CGIA is much earlier in Title 24. And the general rule is we have sovereign immunity, and that applies so government actors can't be sued. However, that is waived if we have waived that as a government. So that's why we created the CGIA, and we created 8 categories in which immunity is waived. I will just tell you what those 8 categories are. Operation of a motor vehicle by a public entity or by a public employee. Operation of a public hospital, correctional center, jail. Dangerous conditions of a public building. Dangerous conditions on a public highway, road, or street. Dangerous conditions of any public hospital, jail, public facility located in a park or recreational facility, public waterworks, public gas, public sanitation, electrical power, or swimming facility. The operation maintenance of a public water facility, gas facilities, kind of all the same thing again as the first one, but just the operation, not a dangerous condition. The operation and maintenance of a qualified capital asset that's subject to leveraged and lease agreement, and then the failure to perform an educational employment background check as required by statute. Those are the 8 categories in which we waive immunity. If we truly wanted this to fall under the Colorado Government Immunities Act, then we would add this as the 9th provision under the CGIA. So clearly, there's not necessarily an intent to really put that under the CGIA, otherwise it would be placed under there. I do appreciate having consistency in law, and I do think that that's something we should always strive for, is that different areas of law should have consistency, similar days, similar terms in which you could be sentenced for. But this concerns a public employee who's working for a health department, and whether or not their liability is either going to be wanton, willful and wanton, or gross negligent. And it's important to understand those differences and why we're wanting to have gross negligent rather than willful and wanton. Willful and wanton rises to almost an intentional tort. It's basically just a hair under, which means that in order to prove liability, the level that this person had acted under is really, really high. Gross negligence is just a hair under that. So it's important that we understand that it's a higher degree of negligence than ordinary negligence. So if you're worried about that, this is still higher. But it does not rise to the level of willful or wanton. It is also sometimes defined as an extreme departure from the standard of care, showing a reckless disregard for the safety of others. I think if you're a public health official, if you're showing a reckless disregard for the safety of others, you should be held to that gross negligence standard. To say that it has to hit almost that intentional level, I mean, that's a pretty high bar to overcome. That if someone is in charge of our public health, someone who we put our faith and our trust in, and we're looking to them for guidance, if they have that reckless disregard for that general safety of the general population within the county, or whatever population that they're charged with overseeing, they should be liable. We shouldn't have that person be able to say, well, it wasn't intentional, but they need to have the onus put on them, the burden put on them, that they're responsible really for the lives of hundreds, if not thousands, or maybe even 1 million or more Coloradans at any given time. And that's not a light job. That's something that should be taken very seriously. And certainly within the private sector, that would be taken incredibly seriously. Because if faulty advice is given in the private sector, even advice in which the person doesn't do their due diligence and it's reckless, that's the level where people get sued in the private sector. They're certainly terminated from their employment because that can result in significant harm. And that's why in this particular space, I would argue that it's inappropriate to try to line this up with the standard that we have in the CGIA, because this isn't just an area that we've waived immunity. This is an area where we've entrusted an official, a highly educated official, who should have more insight and knowledge than the rest of us. And the public is putting their trust in these officials on what decisions that are going to be made. And I want them to understand how important this position is. And that's why gross negligence is very appropriate here. And I would ask for a yes vote on the amendment. Thank you.
Is there any further discussion on this amendment? Number 12. Seeing none, the question before us is the adoption of amendment number 12. All those in favor say aye. All those opposed, no. The noes have it. The amendment fails. To the bill. The question before us is the passage of House Bill 1027. All those in favor say aye. All those opposed, no. The ayes have it. The bill passes. Madam Majority Leader? No. Mr. Schiebel, please read the title of the next bill, which is House Bill 1009.
House Bill 1009 by Representative Morrow, also Senator Cutter, concerning a vegetative fuel mitigation program for a district providing fire protection services.
Representative Morrow.
Thank you, Madam Chair. I move House Bill 10009 and the committee report.
To the committee report.
I want to briefly just describe this bill real quick, and then I'll get to the committee report. This is to allow local control for metro and special fire districts to help address Colorado's increasing threat of wildfires that are caused by extended wildfire season. We do have 2 amendments to the committee report. I would like to move L009 and have it, or L008, excuse me, and have it properly displayed.
That amendment has been properly moved, and we'll just wait for it to be displayed. To the amendment, Representative Morrow.
Thank you, Madam Chair. We did have a robust debate in committee, and I did think that there was some very applicable conversations there, and we tried to address those in these amendments. So L008 exempts land ownership by nonprofits that is leased for agricultural purposes. The amendment does not change the existing exemption for ag land, so that's a reminder. This bill exempts all ag land. And the amendment removes the word dry from the definition of vegetative fuels. And I ask for an aye vote.
Sorry, we're just having a little discussion on whether we're on 8 or 9. We're on 8.
8. Yes.
We're on Amendment 8. Is there any further discussion about Amendment number 8 to the committee report? Seeing none, the question before us is the adoption of Amendment L8. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment passes. Representative Morrow.
Thank you, Madam Chair. I would like to move L10 to the committee report and have it properly displayed.
That is a proper motion. And has been displayed. Representative Morrow.
Thank you, Madam Chair. As I mentioned, we did have vigorous debate in committee, and we wanted to take as many of these into action and put into the bill because there were some very valid points. This amendment further clarifies that an incident covers all vegetative fuels on a property. Therefore, multiple incidents cannot be given at the same time for one property. The amendment requires that the fining letter be sent via certified mail to both the owner of the property and, if applicable, the occupier of the property. This amendment allows the fire district or metro district providing for fire protection services to waive or delay due to weather, contractor delays, or good faith efforts. This amendment further ensures that any liens cannot be used to foreclose on any property and ensures that the lien would not supersede any prior liens on the property. And this amendment requires a participating district to designate an individual to oversee and manage the program, and I ask for an aye vote.
Is there any further discussion on Amendment 10 to the committee report? Seeing none, the question before us is the adoption of Amendment 10. All those in favor say aye. All those opposed, no. The ayes have it. The amendment passes. To the committee report.
Yes, we ask for an aye vote on the committee report as amended.
The question before us is the adoption of the Agriculture Committee report as amended. All those in favor say aye. All those opposed, no. The ayes have it. The committee report passes. To the bill, Representative Morrow. Representative Joseph.
Thank you, Madam Chair. We do have one amendment to the bill, and it's Amendment L009, and we ask that it properly be displayed. I move L009.
Yes, correct.
Thank you, Madam Chair.
Hold on a sec while it gets displayed. Thank you. That has been properly displayed. Representative Joseph.
Thank you, Madam Chair. This is a technical amendment that ensures metro districts provide fire protection services, ensures that metro districts that provide fire protection services are included in the bill. This was one of the original intent of the bill. During committee, there was conversation about what's the difference between a metro district and a special district. Again, I went back and did some research on special districts and metro districts. So a metro district cover more than one service, and a special district tend to cover one service at a time. So again, we just wanted to make sure we clarify the bill and ensure that metro districts themselves are able to provide the type of programming that the bill ensures. Thank you, Madam Chair, and we ask for a yes vote.
Is there any further discussion on Amendment 9? Seeing none, the question before us is Amendment 9 to House Bill 1009. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The amendment passes. To the bill. Representative Morrow.
Yeah, I do want to thank the committee members for having such a vigorous debate and making sure that we try to present as quality of a bill as we possibly can, and definitely heard what you were saying and try to incorporate that in our amendments. And I ask for an aye vote.
Thank you, Madam Chair. We ask for a yes vote on this bill. This is a great bill. Again, when we're talking about fire mitigation around the state, we have to use all the tools that we have in our toolbox. And this is a great bill. It will ensure communities around the states that have metro districts to be able to use this type of programming to ensure fire mitigations in their communities, and we ask for a yes vote. And again, also one more thing I wanted to note, you know, this bill is really about local control. Really, that is the gist of the bill, to ensure that, again, these metropolitan districts have the ability to have the type of programming that they need when it comes to fire mitigation. Thank you.
Assistant Minority Leader Winter.
Thank you, Madam Chair. I would like to move Amendment L007 and ask that it properly be displayed.
That is a proper motion and has been displayed. Assistant Minority Leader Winter.
Thank you, Madam Chair. This amendment, basically what it does is we know that the fire district is elected by the people, but this is a local control issue, and it is a new plan. And I just think that it would be nice if maybe on the next November ballot, if your fire district wants to pick this up, that they would put this on the ballot as well to see that since it's a local issue and each fire district can do this, it's an opt-in. You don't have to do this, that the people are able to kind of direct the fire district that they elected if they wanted to be part of this program or not, and I ask for an aye vote.
Representative Morrow.
Thank you, Madam Chair, and thank you, Representative Winter. I appreciate that amendment. However, I want to remind this body and everyone that this program is already an opt-in, so no district that doesn't find a need for this, they don't have to have it at all. Also, one of our amendments in committee requires public hearing with public comment, and we know that ballot measures are extremely expensive and can be, you know, very, very expensive for these, particularly for these small districts. So I'm asking for a no vote.
The question before us is the passage of Amendment 7 to House Bill 1009. Seeing no further discussion, all those in favor say aye. All those opposed, no. The amendment fails. The noes have it. Is there any further discussion? Representative Sukla.
Okay, so thank you, Mrs. Chair. Madam Chair. Madam Chair. Got half of it right. So I was a volunteer firefighter for 12 years. And Barone, buddy. Anyway, I was a volunteer firefighter for 12 years. It is really hard to get volunteers to volunteer for the fire department. The way that this bill works is it is going to take and it's going to require a special district, which is throughout the state. It is going to take and it's going to make it where a volunteer firefighter that is not getting paid has to go to his neighbor and tell him, hey, you got to cut down that tree. Well, that's not going to work. I mean, you're going to go there and get in a fight with your neighbor because you're a volunteer anyway. The deal about local control is this is being already done. This is a county commissioner job. This is not a special district. This is the first time that I've ever seen where you're going to give a fire department that has, yes, they have a board of directors and they have a fire chief, but they would not be held accountable when they do something wrong. If this is left with the Board of Commissioners, they are voted in by the people, and they can be held accountable if they do something wrong. That's why this is a bad bill. We need to keep it with the county commissioners. Let's don't give it to a special district, and not. Well, I'll tell you what will happen with your volunteer firefighters. What will happen in rural Colorado is your volunteer firefighters are quit. And then what are we going to do? Now we really do have a safety issue when you can't get anybody to volunteer to be a firefighter because they don't want to go make their neighbor mad because they want to cut down a tree. You know, the other thing about the brush, who's going to decide what should be cut down and who shouldn't? What if you planted for instance, a bristlecone pine? It's the most expensive tree in Colorado. They grow 6 inches a year, and it's 10 feet tall. The fire department comes and said, no, you got to cut that tree down. It's a $3,000 or $4,000 tree, and you have no recourse. The other thing is when we talk about a lien on property, once you put a lien on property, whoever owns that mortgage, right away, they can claim that they want their payment for that mortgage. So they can fast track the mortgage, and this bill right here, what it would do is it would cause a homeowner, somebody on a fixed income, to lose their home because they didn't cut down their lilac bush that they wanted them to cut down. I would urge a vote no on this bill. Thank you.
Members, let's take our conversations off to the side, please. We're getting a little loud here. Representative Johnson.
Thank you, Madam Chair. In committee was a no vote. We did pose a lot of questions. Thank you so much to the sponsors for doing due diligence on these and getting back with all of these amendments. Very much appreciate this. This is the way the process is supposed to go with stakeholdering. I am still a no because there is a lot of ambiguity. This is clear as mud. There are so many questions that are still left, and the answers we received in committee were leave it to local control. When asked, does this give fire districts the ability to create their own rules and issue fines directly? The answer was, let the local decide. When we asked on whether how inspections of private property would take place, the answer was, let the local decide. There was a precedent set in the committee, we need to let the local decide. Right now, fire districts are already authorized to levy a sales tax to pay for safety protection, street improvement, transportation purposes. This is an expansion of quasi-independent government's ability to fine property owners. The way we do taxes in the state is it has to be brought to the people. The people want to vote no, that's the people's decision. That is local control. I love our fire departments. I love our firefighters, all first responders. We need fire mitigation in the state. I really appreciate the passion that went into this bill, but there is so much ambiguity. And when the answer is leave it to local discretion, why are we handling it at the state? Why don't we let local control do what they do best? I urge a no vote.
Representative DeGraff.
Thank you, Madam Chair. I share my colleagues' concern by, a lien could be a good idea in the sense that it goes against the property, but if it does allow the property to be fast-tracked, that can just be used as an excuse to get somebody off that property. One thing that we know about legislation is that if it can be weaponized against you, it will be weaponized against you. So if somebody wants to get somebody off a property, they'll be able to use this bill to do it. Go in, make some claims, say all these, because I don't see any recourse in here. And we also have, and when we say local control, I'm not really sure how fire districts are local control. They're elected, broader area, they're not your county governments, they're not your municipal governments. Your county and your municipal governments, those are your fire districts. So those are your local control. We have these districts, and why do we have these districts? We have these districts so that they can do end runs around Tabor. Now you have another end run around Tabor in that you can levy more fines, more fees in order to support the fire district. So more end runs around Tabor. So this is not local control. It looks like local control because it's fire districts, but those overlap. Those are not county governments. Those are not the responsive governments, and it puts them in a position. It also puts them in a position where the fire department is the bad guy. Now the fire department also has to come out and identify the risk and mitigate the risk, and now they have to step outside of their area of expertise. And most of these places don't have full-time fire. This is not a task to put on our local fire, especially not our volunteer fire, just to pile on more and more because, it's almost like farming. Farming looks easy when you're 1,000 miles away and your pen is a plow. But here, we just look at it and say, wouldn't it be a great idea if we could solve it from this room? But you have absolutely no idea what the implementation of this bill is going to entail. You don't have any idea what the load is going to be on the fire districts. Who's going to make these decisions? Who's the determination? How this bill is going to be weaponized? It will be weaponized. It's pretty easy to see how it will be weaponized. So I think we need to consider all these things before we just put our good intentions into motion again.
Representative Taggart.
Thank you, Madam Chair. It's an honor to serve with you.
Honor to serve with you, sir.
I have a couple concerns about this bill. First and foremost, my city and my county already have ordinances on this subject. So it's redundant. And secondly, if we give the power, as this bill does, to the fire districts, now the fire districts are potentially in conflict with ordinances that already exist. I can assure you, when I was mayor of the city and we put our ordinances on this exact subject, we had the fire districts and our fire chief in the room to discuss it long before we went to public hearing. I agree with local control, I always will, but putting conflict in place between a fire district and a county and a municipality, to me, does not make a great deal of sense. And on top of that, these types of ordinances exist and we need to respect them. Thank you.
Is there any further discussion on House Bill 1009? Representative Sukla.
Madam Chair, one other concern that I have is fire districts overlap. So for an instance, when I was on the fire department, one district overlapped with the other district 1 mile. We called that the neutral zone, meaning that whichever fire department could get to within that 1 mile, could get there first, they were the first one to put out the fire. When the call came in, both fire departments went to that area, between the two districts. Using that scenario, in that 1 mile radius between the two fire districts, what happens when the landowner, they're like, okay, you got to do the fire mitigation. One fire district goes to the landowner and says, okay, it's going to cost you $500. You got to take this bush out and this and this. Then the landowner goes to the other fire district, and that fire district says, well, you only have to take out these 3 things. You see what I'm talking about, the confusion here, where there's this no man's land between the fire districts, versus if it was put straight to the counties, and not talking about the metro, where she's fixing to come and line me out here, then it would put us in no man's land. And that's why we need to protect our counties. We have a way to do it through the counties, the rural counties, and I'm very concerned that this will affect our rural counties in a negative way. Thank you.
Representative DeGraff.
Thank you, Madam Chair. And I really do appreciate at least the attempt to go to and say it's about local control, which I don't know. After this morning's bill saying that this is important because it's local control, I mean, it does make me laugh. Especially when it turns out to not really be about local control. It's about fire district control. It's about conflicting with local control. It's about circumventing Tabor some more. It's about increasing some liability for the fire district because now they're responsible for coming up with these rules that they didn't have to otherwise. Otherwise, they're going to have to adopt them from the cities. But how is a fire district that overlaps different areas going to now have to consolidate all of these different aspects? But none of that matters. Good intentions. That's all that matters. Good intentions. I think there's enough things that have been identified here that maybe this bill could solve a problem. I don't know. But if it doesn't solve a problem, it creates redundancy and repetition. Then I'm questioning why have it. Counties have it. Counties have ordinances. Counties can do all these things. Why is this considered local control when it's not? Why do we pretend we value local control when we don't? So, anyways, I think these are all good things that we need to ask. We need to find out. We need to stop. We need to slow down the bill mill. Maybe every good intention doesn't need to come out the other side. This is something that's being imposed on the people of Colorado. It's already taken care of. It's usurping local control. So I would just like to refer it back to seconds. So if I have to move it, I move that this bill be returned back to seconds. I mean back to committee. I'm sorry. I'm sorry. It needs to be returned to committee. Which one?
Can you make the motion again, Representative DeGraff?
I move that this bill be returned to the committee from whence it came.
The question before us
Agriculture.
is to move this bill back to Agriculture Committee. All those in favor say aye. All those opposed, no. That motion fails. The question before us is the adoption of House Bill 1009 as amended. Seeing no further discussion, the question is the adoption of House Bill 1009. All those in favor say aye. All those opposed, no. The ayes have it. The bill passes. Mr. Shebel, please read the title of House Bill 1138.
House Bill 1138 by Representatives Lukens and Puglisi, also Senators Kirkmeyer and Doherty, concerning evidentiary requirements to protect victims of sexual misconduct in civil suits.
Representative Lukens.
Thank you, Madam Chair. I move House Bill 1138 and the Judiciary Committee report.
To the Judiciary Committee report. Minority Leader Puglisi.
Thank you, Madam Chair. We made some technical amendments in committee, and we would ask for an aye vote. Thank you.
The question before us is the adoption of the Judiciary Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The report passes. To the bill, Representative Lukens.
Thank you, Madam Chair. This bipartisan bill provides critical updates to Colorado's civil rape shield law to ensure that survivors are protected throughout the legal process. It preserves fairness in the courtroom, protects privacy and discovery, and aligns standards across civil and criminal law. We ask for a yes vote.
Thank you, Madam Chair. It is never okay. It's never okay to rape anyone. It is never okay to sexually assault anyone. It is never okay to human traffic anyone. It doesn't matter your sexual history or what you look like or what you're wearing. It is never okay. This bill will conform civil law with criminal law. We passed the criminal rape shield updates last session. We are now updating the civil statutes, and we ask for an aye vote. Thank you.
The question before us is the passage of House Bill 1138. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The bill passes. Majority Leader Duran.
Thank you, Madam Chair. I move the committee rise and report.
You have heard the motion. The committee will now rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1009 as amended, 1027 as amended, and 1138 as amended, passed on second reading, ordered, engrossed, and placed on the calendar for third reading and final passage.
Thank you, Mr. Shebel. We do have amendments at the desk. Mr. Shebel, please read the Luck Amendment to House Bill 1027.
Representative
first
Luck
Luck
moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Luck Amendment L16 to House Bill 1027 to show that said amendment passed, that House Bill 1027 as amended passed.
Representative Luck.
Thank you, Madam Speaker. I move the second Luck Amendment to the Committee of the Whole and ask that it be displayed.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. This amendment actually amends the underlying amendment, and so just for ease of this process, I ask for an aye vote on this. Basically, all this is saying is it's adding school districts into the underlying amendment, so I'd ask that you allow me to correct the underlying amendment such that then I can propose the underlying amendment for an actual substantive vote, so I ask for a yes. Thank you.
Representative Gilchrist.
Thank you, Madam Speaker. I urge a request of no vote on this amendment.
Thank you. Seeing no further discussion, the motion before us is the adoption of the second Luck Amendment to the Committee of the Whole report. Mr. Shebel, please open the machine and members proceed to vote. Representative Brooks, how do you vote?
Yes.
Representative Brooks votes yes. Basenecker is excused. With 22 aye, 41 no, and 2 excused, the amendment is lost. Mr. Shebel, please read the first Luck Amendment to the Committee of the Whole report.
Representative Luck moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Luck Amendment L7 to House Bill 1027 to show that said amendment passed, that House Bill 1027 as amended passed.
Representative Luck.
Thank you, Madam Speaker. I move the first Luck Amendment to the Committee of the Whole and ask for it to be displayed.
It is fuzzy, but properly displayed. Please proceed.
Thank you, Madam Speaker. By raise of hands, how many of you live in a community where there is one or less stoplights? Anybody? All right, a couple of us live in a community where there is one or less stoplights. I think in the entirety of my district, we have about 30 stoplights between the 5 different counties. I think I go through 30 stoplights just getting off the highway and getting here, which goes to this particular amendment, because under this amendment, the governor would continue to have his executive authority to declare states of emergencies and solely govern for the first 30 days when it is a situation involving an epidemic or disease. But after those 30 days, he would then have to share, under this amendment, his jurisdiction with other elected officers who are actually known by the people, the ones who are seen in the grocery store and at church on Sunday and out and about in the community, the ones that are directly responsible in the most amazing of ways to the people. And by allowing for this concurrent jurisdiction, basically what has happened is after the 30 days have expired, those first 30 days, the governor can continue to renew his or her executive orders, but the local jurisdictions can say, you know what, this part of that executive order as relates to this particular disease response doesn't apply to our situation. And you heard countless stories from former county commissioners as to how that actually transpired during the COVID era and how necessary this particular provision is. And so for those of us who have one or less stoplights in our communities, I urge an aye vote.
Representative DeGraff.
Thank you, Madam Speaker. I urge an aye vote from communities that have lots of stoplights. My community has lots of stoplights. And one thing that I know about an emergency, say you go to an emergency room only deals with issues that are emergent. They're crisis right now. It's not urgent care, that's a little bit lower standard. And it's not chronic. When you get beyond 30 days, you're dealing with chronic. So even having the governor have emergency authority beyond 30 days, you are now dealing with a chronic issue, not an emergent issue. It's not a crisis. If it's going to last longer than 30 days, you now need to learn to probably live with it for the long term. Not cede control to a single individual who is not magically imbued with all kinds of benevolent dictator qualities. So I urge a yes vote for this. Again, we have the pretense of local control on the previous bill as a good thing. We have the complete abolishment of local control with this bill. Now, in my mind, I don't think we actually need this because the locality should have just said on the executive order that the governor can pound sand. That's what I think the groups should have done. And they should have recognized that the citizens are sovereign. Their job is to protect the citizens of Colorado from this body right here when they step outside their lane and no longer see their role as securing the rights of the citizens, which is then all morning, all day, afternoon. I guess we're in the afternoon. So I don't think we really need this. I think the local governments need to relook at their charter, look at their purpose, look at the purpose of this government, and when they see this bill come up, they need to assert their authority as the representatives of the citizens and to secure the rights of the citizens against an overreaching, oppressive nanny state. This is the nanny state. And local governments need to remember that this body should be working for them, and this body should be working for them and working to secure the rights of the citizens, not impose all of their good intentions. I recommend an aye vote on this just because it helps clarify that issue. It helps encourage the overreach that happens in this body day after day after day, tries to at least codify in there that maybe the government, that this state level, Denver imposed, Denver centric, everything Denver centric, that it is not a good way to govern, and that our local governments have the best interest at heart, and that we need to have a little bit more citizen initiative, local government initiative to step outside and push back, because this body is never going to relinquish any of its overreach. So to the county governments, local governments, you're just going to have to stand up, because this body will roll over you every chance it gets.
Representative Gilchrist.
Thank you, Madam Speaker. I urge a no vote on this amendment.
Seeing no further discussion, the motion before us is the adoption of the first Luck Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Brooks, how do you vote?
Yes.
Representative Brooks votes yes. Please close the machine. With 22 aye, 42 no, and 1 excused, the amendment is lost. Representative Froelich, will you make our motion? The motion before us is the adoption of the report of the Committee of the Whole. Mr. Schiebel, please open the machine and members proceed to vote. Representative Brooks, how do you vote?
No.
Representative Brooks votes no. please close the machine? With 42 aye, 22 no, and 1 excused, the report of the Committee of the Whole is adopted. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar to Friday, February 7th, 2025.
The balance of the calendar will be laid over until tomorrow. Announcements and introductions. Representative Leader.
Of course, ma'am. Thank you, Madam Chair, and thank you, Madam Speaker. It's a pleasure to serve with you.
It is a pleasure to serve with you.
I would like to take a moment to welcome, who has now left, the staff and residents of the Ridge Pinehurst who were here with us today at the Capitol for the Leading Age Colorado Day on the Hill, which represents the aging services continuum of the providers in the state of Colorado. So I would say please join me in welcoming them. However, they have gone, but we can still welcome them. So please give them a round of applause. They did stay here for a very long time. Thank you.
Thank you. Representative Wilford.
Thank you, Madam Speaker. The State Civic, Military, and Veterans Affairs Committee will be meeting 5 minutes upon adjournment across the street. LSBA hearing for action only House Bill 1065. See you there.
Thank you. Representative Lukens.
Thank you, Madam Speaker. The House Education Committee will be meeting upon adjournment of the upon adjournment committees. And we're just going to start right when the last committee wraps up from the upon adjournment committees. We will be hearing House Bill 1041 for action only, and we will also be hearing House Bill 1131. Thank you.
Representative Lindstedt.
Thank you, Madam Speaker. The House Finance Committee will be meeting about 10 minutes on adjournment downstairs to hear House Bills 1005 and 1157.
Thank you. Representative Ricks.
Thank you, Madam Chair. House Business Affairs and Labor Committee will be meeting upon adjournment of the upon adjournment committees. In room 112, we'll be hearing one bill prohibiting price gouging in sales of necessities. See you there.
Representative Zokai.
Thank you, Madam Speaker. I've requested to be excused tomorrow, February 7th, and been approved by the Majority Leader.
So approved. Representative Brown.
Thank you, Madam Speaker. Tomorrow morning, the Colorado Association of Naturopathic Doctors will be having their legislative lobby day breakfast outside the old Supreme Court chambers from 7:45 to 9 a.m. Hope to see you there.
Representative Valdez.
Thank you, Madam Speaker. Energy and Environment. We will be meeting today, finally, after the adjournment of the adjournment committees. And so we will be hearing one bill today, 1051, Old State Library. Be there or be square. We'll keep you all updated on the time.
Great, thank you. Minority Leader Puglisi, Caldwell, and Kelty.
Thank you, Madam Speaker. I actually have the El Paso delegation here. We had school board members and administration folks from Colorado Springs in my school district and where my children go to school. They were here earlier. They're not here today, but I wanted to welcome them. And there was also Chipeta Elementary fourth graders also in my district who were here earlier watching us all debate. I hope that they learned something and one day run for office. So I just wanted to welcome them to the Capitol. Thank you.
Woohoo. Representative Soper.
Thank you, Madam Speaker. Members, I actually have 3 announcements. First, I have been granted approval to be absent till 1 p.m. tomorrow to attend a funeral and then remote after that.
So approved.
Second of all, if you're on legal services, raise your hand. Yep, thank you. Tomorrow morning at 8 a.m., we have a meeting in committee room 0112, so please be there. We're overseeing kind of the budget numbers and how those look. And then lastly, tonight is the Broadcasters Association at the University Club at 5:30 p.m.
Representative Carter.
Thank you, Madam Speaker.
You bet.
I want to recognize I also have individuals that were here early. Sorry. I also had individuals that were here earlier from the Aurora Public School Board, as well as two individuals. I don't know if you remember, it was a while back. We had two individuals from my school districts that said the Pledge of Allegiance, and that's Murphy Creek Middle School. Also had a member from Teachers on the Floor earlier from Marachek Middle School. Just to give you really quick, there are over 1 million students in the state of Colorado. There's about 1,000 school board members, about 160 school boards, and of that number, 5 black men serve as school board members, and of those 5, 2 of them are on the Aurora Public School Board. So I'd appreciate your standing and acknowledging Aurora Public Schools.
Great. Representative Tatone.
Thank you, Madam Chair. I have permission from the Majority Leader to be excused on the morning of the 14th.
So approved. Representative Lindsay. Could it be?
Thank you, Madam Speaker. Could it be? Capitol Choir, come down to the front. We have a birthday. It's Rep. Ryden's birthday. Come down so we can sing to you. I don't ever want to be by the mic. Here, you go by the mic. I don't want to be by the mic.
Set the tone, you know.
Representative Ryden, you're not close enough for us to see your blushing cheeks. Junie, you want to kick it off?
Birthday to you. Happy birthday to you. Happy birthday, dear Ryden. Happy birthday to you.
And many more. I think that's, oh, I have an announcement. Today only, Representative Zokai will be replacing Representative English on Business and Labor. Thank you. Almost forgot. Madam Majority Leader.
Thank you, Madam Speaker. Members, tomorrow is the deadline for you to introduce your last 2 bills. OLLS asks that you
Madam
find
Majority Leader, members, this is a really important announcement. Please pay attention.
Thank you, Madam Speaker. I'll start over. Members, tomorrow is the deadline for you to introduce your last 2 bills. OLLS asks that you finalize your bills as soon as possible so that they can have all of the bills delivered in a timely manner. Thank you. With that, Madam Speaker, I move the House stand in recess until later today.
House will stand in recess until later today.